So just so everyone kind of knows the lay of the land, we're actually having two meetings. The first is going to be a joint meeting between the Gilliam County Court and the local contract review board, which for folks who don't know who that is also the Gilliam County Court. So it's kind of a funky, we're sitting as two bodies simultaneously for the next couple of minutes. So it's 10 o'clock, so I will go ahead and open. This is a joint hearing of the Gilliam County Court and the local contract review board. This is the time duly set and advertised for a joint public hearing between the Gilliam County Court and the Gilliam County Local Contract Review Board. The purpose of the hearing is to receive public comment on Gilliam County's draft findings supporting the exemption of certain classes of special procurements and public improvement contracts from competitive bidding requirements. This is a legislative hearing. All those in attendance that wish to testify are asked to receive recognition from the chair, then state your name and address for the record. The hearing is now open. So I'm just seeing folks, I'm looking to see if anybody is interested in testifying. If you dialed in via your phone, then you need to hit *6 to unmute yourself. And if you signed in via the Zoom link, then you can unmute yourself in the lower left-hand corner of the screen. So does anybody wish to provide public comment? I'll give just a second to make sure. Anybody? Anybody? I am not seeing anyone, so I will go ahead and close the hearing then. The hearing is hereby closed. The next thing that we move into as the joint meeting is to consider approval of resolution number 2020-31, a resolution opting out of the Attorney General's model public contracting rules and amending public contracting rules for Gilliam County. So just as a little bit of background, the last time the county adopted public contracting rules was back in 2016. And so those needed to be updated to remain in compliance with state procurement law. And so we're doing this joint hearing. Both bodies have to approve them. So us as the county court and us as the local contract review board have to approve those. The resolution, all of that kind of stuff was drafted directly from our legal counsel. Carrie Connolly is a procurement specialist with Local Government Law Group. So she's the one that drafted all of these. Most of the rules in here are really prescripted by state law and the Attorney General's office. So the only place that we really have much authority to do much of anything is within the exemptions of the document, so that you guys know. Any questions about it?
I didn't have any. We went through this process when I worked for the city, so I didn't have any questions.
I have no questions.
All right, do we have a motion then?
I move to adopt resolution number 2020-31 on behalf of Gilliam County Court and on behalf of Gilliam County's Local Contract Review Board as presented.
I second.
It's been moved and seconded that we adopt resolution number R 2020-31 on behalf of the Gilliam County Court and on behalf of Gilliam County's Local Contract Review Board as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, so with that, that is the only thing that we had to take care of as the joint sort of joint bodies. So I am going to go ahead and adjourn that joint meeting. It is 10:05, and so I then am going to call the regular Gilliam County Court meeting to order at 10:05. And I see that Commissioner Wilkins and Commissioner Weatherall are here, so we have a quorum. And we've been dispensing with the flag salute since we're on Zoom, and that's a little awkward for everybody. So I'll go into 2.0, which is additions and revisions to the agenda. Do you guys have anything? Anything you want to add to it?
No.
No, not today.
Okay.
Take a couple things off.
Exactly. There's a lot on there today. So we'll go into correspondence and public comments. We'll start with public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to be recognized by the chair, give your name and address, and limit comments to 3 minutes. And again, folks who have known us around here know that you are welcome to interrupt as well. You don't have to, it's not just during public comment. We're happy to have you sort of participate throughout the meeting. But for now, does anybody have any public comments? And if you dialed in, again, you'll just want to hit *6 to unmute yourself. And if you came in online and are watching it from your computer, then your little mute button's on the lower left-hand side. Any public comments? I don't see any. All right, under correspondence, we have a couple of items. One is just an update from the City of Condon regarding their grant summary for their infrastructure grant for the fiscal year, where those funds were expended, and sort of what they're working on. And there's some financials attached to that. So that will be part of the record for folks who would like to see those financials and the update from the city. Those will be on the county's website with our agenda materials. And then the other piece comes from the USS Oregon Commissioning Committee, basically just talking about a christening ceremony that they had and asking for donations for the USS Oregon. So I wasn't sure that this was something we necessarily wanted to follow up on, but I just wanted to flag it for the record since it was sent to all three of us. Let's see. We are a little bit ahead of schedule for the second public hearing that we have. So why don't we go ahead and try to dispense with the consent agenda, and then we can come back to the hearing.
I did not have any questions on the consent agenda.
I did not have any questions on the consent agenda either. How about you, Judge Farrar?
Nope, I'm good.
Okay, I move we accept the consent agenda.
Second.
It's been moved and seconded that we approve the consent agenda, which consists of consider approval of September 16th regular meeting minutes, consider approval of September 16th work session minutes, consider approval of September bills pending review, consider approval of 2020-2021 Transportation of Veterans in Highly Rural Areas Grant Agreement, and consider appointment of Commissioner Weatherall, Susie Anderson, and Marta Michaelo to the Gilliam County Board of Property Appeals, or BOPTA. Is there further discussion?
Nope.
All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, we will just hit pause momentarily. Let me see. Let me get this organized. I think we might actually have time to start into unfinished business with this first agenda item, I think. So why don't we try to tackle 6.1, which is consider approval of intergovernmental agreement for fire coordinator services. So if you remember, about a little over a year ago, Sheriff Betancourt talked to us about our legal counsel helping to redraft the IGA for fire services because it was outdated. And so for the last several months, he and I and county council have been working to update the agreement. Basically, what was happening is we were increasing our financial contributions and things like that, but the agreement was never being updated to reflect those. So the draft before you reflects the current contributions that each of the 5 parties are making, which is for those who are not familiar with our fire services board, that's Gilliam County, the City of Condon, City of Arlington, North Gilliam Fire District, and South Gilliam Fire District. We also put in place a way to make sure that if the budget, as the budget grows, if it reaches over 87,000, that we have a way, rather than having to open up the IGA again, that basically the contributions will just be based on a percentage that's established in here based on the current percentage of contribution. So Gilliam County takes the bulk of that, obviously, and then the cities each pay a percentage and the fire districts each pay a percentage. And then the other thing was just making sure that all of the legalese that would normally be in all these IGAs was up to date and current. The version that you have before you was drafted by county council. The Fire Services Board did initial review of it, said it looked good. It has to go to all of the governing bodies for approval, and so when the City of Condon looked at theirs, they had some additional language they wanted to add as far as what would happen if it dissolved and things like that, which was acceptable language. It's language that we put into like our Fiber Council agreement, things like that. And so basically the sheriff is recommending that we go ahead and approve the IGA as presented. Questions about it or concerns?
I didn't have any. I can't believe that's been, they put this together when I first started working at the city. So it's been going for a long time and it seems to be working pretty well. And I don't have any concerns about moving forward with a IGA.
And I went ahead and forward dated it just so that it'll actually become, even though we're taking it up today, it'll become effective on January 1, just so it was a clean in case the other governing bodies take some time to get it on their agendas and approved. That way we don't have to go in and fix dates later if it takes them some time to get to it. So do we have a motion?
I move to approve the intergovernmental agreement for fire coordinator services as presented.
Second.
It's been moved and seconded that we approve the intergovernmental agreement for fire coordinator services as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, the motion carries. All right, I'm going to set this aside. We are like 2 minutes away from the actual hearing. So I'm just going to pause for 2 minutes rather than get us in the middle of another discussion, because the next one I think will take a little bit longer under unfinished business. And then, so here in another minute or so, we'll start the public hearing on the Economic Enhancement Fund.
Judge Farrar?
Yes.
I have a communication from Molly Rogers of Norcor. She has sent me a document with a sub-agreement, and that is our agenda item number, whatever that is.
7.2?
Oh, yeah. So I will forward this to everyone. And we can have that to look at as we're discussing that.
Okay, sounds great. Okay, while you're forwarding, Sherry, I'll get us going on the next public hearing. So it's 10:15, and so this is a public hearing. I'll call the public hearing to order to receive public comment on revisions to the Economic Enhancement Fund ordinance. This is the time duly set and advertised for a public hearing in the matter of the Gilliam County Economic Enhancement Fund ordinance. The hearing is for the purpose of taking public input on proposed revisions to the Economic Enhancement Fund ordinance, which governs the distribution and usage of host fees from Waste Management Incorporated. This is a legislative hearing. All those in attendance that wish to testify are asked to be recognized by the chair, state your name and address, and then state your name and address. The hearing is now open. So for those who are dialing in, I see two folks who've dialed in with their phones. You'll just need to hit *6 to unmute yourself. And so we are now accepting public testimony. So would anybody be interested in providing testimony or input? Anybody? Again, just hit *6 if you're on the phone and would like to provide input. I'll give folks a minute because sometimes it's tricky to get it. I'm not seeing any, but I want to make sure since it's important to the community. There's a phone number, last four digits are 2851 and one that is 7108. And I'm wondering if either of those folks would like to make public comments. I just want to make sure. If so, you just need to hit *6 to unmute yourself.
Liz, this is Chris at the Sheriff's Office on the 2851.
Oh, good. You don't have anything. Okay. So I'm assuming the 7108 does not either. I'm going to give them one more minute just in case because I don't want to shut anybody out from having the opportunity.
7108 is Judge Patnode.
Oh.
No comment.
Okay.
Morning, Chris.
I'm not able to comment under the Code of Judicial Conduct anyway, but.
Okay. I just didn't want to I wanted to make sure there wasn't a member of the public who was desperately trying to protect themselves. Okay, so it does not look like we have any public comments on this, so I will go ahead and close the hearing. The hearing is hereby closed. And then we'll move into consideration of first reading of ordinance number 2020-02 in the matter of the Gilliam County Economic Enhancement Fund. So because this is an ordinance, commissioners, it has to be read twice, 13 days apart, in that funky little two-part motion that we do with the first reading and acceptance of the first reading, those kinds of things. So again, this is based for the public's edification so that you know how we got to this point. On September 16th, the county court held a work session where we went through basically section by section this entire document. And so the revision before us captures those changes that we discussed during the work session. And again, they're mostly administrative cleanups, but some policy clarification for the assessor and the treasurer as they implement particularly the homestead rebate. So with that, I'll turn it over to you guys, commissioners. Do you have any discussion on the ordinance?
I have none.
I have none. I move we have the first reading of ordinance number 2020-02 by title only.
I second.
It's been moved and seconded that we have the first reading of ordinance number 2020-02 by title only. Is there further discussion?
No.
All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion passes. Okay, so I will read the ordinance. In the County Court for the State of Oregon for Gilliam County, ordinance number 2020-02, in the matter of the Gilliam County Economic Enhancement Fund.
I move to accept the first reading of ordinance number 2020-02 by title only.
I second.
It's been moved and seconded that we accept the first reading of ordinance number 2020-02 by title only. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, so we will schedule the second reading for the next regular meeting that we hold on the 21st. And we'll move that one forward. Okay, now back to our regularly scheduled program here on 6.2, which is discussion regarding Airbase Road project. So to recap, back in early February, Radar Holding, which is John Barnett and Maggie Cooper, came to see us. They own and manage the property at the old Radar Air Base Station west of Condon. And they were requesting that the road department assist the community there in replacing the road. So at the time, Roadmaster Kennedy was there. He expressed an openness to performing the work as long as those additional funds did not come out of the road department's budget. And then at the time, he estimated that the project would cost around $70,000 and could be completed in this now current fiscal year, 2020-2021. And then just for the record, we had determined during that meeting, based on a review of the commissioner's journals, that Gilliam County, although it was a local access road, Gilliam County had never accepted responsibility for that. And so it remains a local access road, so it's not a county road, it's not the county's responsibility. And so if we decided that we wanted to do work on it, in your briefing, it sort of lays out that process that the county would need to undergo. So basically, the county road official would need to recommend the expenditure. We would have to find that the public use of funds justified that expenditure, and then we'd have to enact an order or resolution authorizing that work, and then designating whether that's a single project or an ongoing maintenance agreement. So at the time, we had agreed to revisit this after the budget committee had gone through its processes. And I recently had a discussion with Radar Holding, just throwing out an idea, given our focus on trying to get affordable housing or housing stock up and available, that something we might consider doing is allowing or enabling the road department to do the work as a one-time thing, but asking in exchange that Radar Holding put, there's several homes out there that need to be renovated so that they're either able to be sold or put on the rental market, and that we might consider doing a trade, basically, where if they were willing to put a certain number of rentals on or houses on the market, that we might consider fixing the road. So I just wanted to throw that out there, and really the discussion today is just to gain some clarity on, number one, do we feel comfortable having the road department do the work? And if so, are there any stipulations or things that we would want to request of Radar Holdings in exchange for the county paying for that work being done? So I'll turn it over to you guys for your thoughts.
Well, I am not familiar with the access road that we're discussing, so I would like to see that, and I would like to see what the possibilities are for housing, and get maybe some type of proposal from Radar Holdings on what they would give us in exchange.
Okay. So are you guys thinking, I mean, we could do this in one of two ways. We could, it's a little bit tricky. Usually we do, when we do like our road tours and stuff, we all sit on a bus, and I'm not sure we can do that. So would you guys prefer to just connect with John and Maggie and arrange to go out there, and maybe in an upcoming meeting, just invite them to come to court and talk about maybe what a potential trade would look like?
Okay.
How can I facilitate is what I'm asking.
Yeah, I'd like to get the opportunity to drive out onto the, and see what we're talking about and what condition the road is in. And I've honestly never been to the air base, so I don't know what the homes look like, or I'd just like to educate myself a little bit before committing.
Okay.
I think that's a good idea. I agree with that. I think that's a good idea. I have been out there, but it's been a while, so it wouldn't hurt me to take a trip out there too. And I could probably get a hold of the roadmaster, and Sherry and I could do that individually if we wanted. And I'm sure he'd be willing to show us around as well.
Okay. So how about this? How about we each independently make contact with John and Maggie and Dewey and set up, to avoid having a public meeting where it becomes a little bit more logistically difficult to keep everyone distanced, if we can just each do that on our own. And then once you guys have had an opportunity to take a look at it, if you can just let Teresa know, and I can get it put back on the agenda for a future discussion and ask Radar Holding to join us then at that point. Does that make sense?
Yes.
Yes.
Okay, that's what we'll do then. More to come, I think is what we're saying. Okay, next one up is 6.3, which is discussion and possible action regarding the Holland & Sons warehouse. And I will kind of cue this up, but I see Jeff on here and Catherine as well, so they may be able to fill in some gaps since this started before we were on all three of us were on the court. So basically, just to recap, during our last meeting on the 16th, the Safety Committee, Teresa was presenting the Safety Committee's recommendations, some of the projects they'd like to focus on. One of the issues that came up was the Holland & Sons warehouse and the sidewalks in particular, the condition of the sidewalk here in Condon. And so we had decided as a group that we would like this to come back to the county court. And so we did a little research in between the last meeting and this one. The previous court had discussed demolition of the building and repairing the sidewalks, and had actually taken several steps toward that. So the court had received a project management proposal from Pillar Consulting. The City Planning Commission had approved the demolition. And then the State Historic Preservation Officer, SHPO, had offered no objection to the proposed demolition. It is a historic structure, but they did not raise an objection to it being demolished. At that time, the county court, the previous county court, didn't take any action, so it just kind of, I wouldn't really even say died, it just sort of was put on pause, I guess. And so we followed up with the city to just see if that planning commission approval is still valid or if we'd have to go back through that process. And I think, and Catherine can correct me if I'm wrong here, but it seems like there was no time frame put on that approval. So long as those, I was going to say, as long as those original conditions of approval are met, then it would still be approved for demolition. Did I get that right, Catherine?
Yes. Dan Meter added one other thing, is he just wanted to make sure that you guys documented the history of the building. And I think if you don't have the documentation for it, when they put that in the historic district, I believe that we have that in the historic, I mean, at least up until they did the historic district, they have the information on that. Might have to add a few more things on once the county bought it and what it's used for. But yes, there is no time limit on it. It's been approved by the Planning Commission that also SHPO is aware of it. So you're more than welcome to take it down. Please do.
Yeah,
Please.
what advantage is that going to give the city and the county and our residents if we do take it down? What's the advantage to that? Is it a safety hazard? Is it?
There's some, I think, safety, but I also think the sidewalks along there, I don't know what exactly it's being used for, I think, but what would be nice to have is additional parking. I don't know. I think another thing is we need to know what the county's going to do with it. And that was the big discussion when we talked before, is what are your plans to do something? And in the meantime, it would be awfully nice to have more parking. As we all know, when something's going on Main Street, and if the hotel's full, there is not a lot of extra parking around in that area. So if it was fixed and turned into a parking lot, that'd be great. Because also too is right next door is your newly leased senior services, where the vans are, the bus barn. And so, I mean, you guys might have some other ideas what you want to do with it. But that would be a good first start, is to take it down and turn it into parking until you decided if you wanted to put something else up on that location.
Okay.
Have you heard anyone express any interest in that lot over a few years?
No. We didn't have any interest, any extra people against it at the Planning Commission meeting over 2.5 years ago either. I don't know. There's some other vacant lots on Main Street. I have not. I'll just put it that way. I have not heard any other people interested.
My other question is the funds to do this project, what budget line item would that come out of?
So we would probably take that out of the capital projects fund. There's about, I think about $1 million sitting in that account. So there's plenty.
Okay.
I have a question. It's probably should be directed at Jeff possibly, but how much ballpark do we anticipate a project like this might cost?
Jeff, are you there? See him on there. Hopefully he's not distracted. Hey, Jeff. Maybe.
I think he's distracted.
He might be distracted. He's probably on
I don't know if that building has any asbestos in it, but I wouldn't think, or any salvageable material, you know, if you could salvage anything out of it. We couldn't on the Reeser building. We thought we could salvage some beams or something like that, and it wasn't. But it'd be interesting to know if it did have asbestos on the shingles on the side. That would be spendy.
Yeah. But maybe another reason to take it down too.
Exactly.
It has asbestos, yeah. Let me see if I can get Jeff to look at his phone here.
Oh, he's unmuted.
Hi there.
Hey, Jeff. So we were talking about the Holland and Sons building, and Leslie had a question about what it would cost roughly, do you think, to take the building down?
The demolition alone.
Mm-hmm.
It's been a while since I've thought about it, but I would think it would be I'm going to say it's going to be in the $10,000 to $20,000 range.
And then what other costs are we looking at to get from start to finish?
Well, it depends where you want to finish. So
parking, say just parking and a sidewalk.
Yeah.
So there's about, if we do sidewalks on 3 sides, there's about 150 linear feet of sidewalk at, that's going to be probably, with everything involved, probably close to, hold on. That's probably at least, I'm guessing that's $15,000 there probably. And then for parking, depends whether we want to grade it, how we want to handle stormwater and all that kind of stuff with it. It's roughly 5,000 square feet at $10 a square foot, $50,000 there. That seems low, to be honest with you, in this market.
So we're looking at around 100,000.
I think so, yeah. Depends whether you want to pave it or not.
Right? Yeah. Whether Dewey wants to pave it or not.
There you go. Right. Yeah. So there's going to be some cost there involved with it. But yeah, I think that's probably not, it's a 5,000 square foot lot or ish, 5,000 square feet. So that's, and that's in the neighborhood of $20 a square foot to do a parking lot and to do sidewalks and stuff around the outside of it. I don't think that's out of line. No.
Okay. Thank you, Jeff.
You bet. Yeah, and based on, I think, the proposal that I'd submitted, that's consistent. My thinking is for that kind of work, lots of times the engineering's around 10%. So that, the total professional fees, a little bit more for smaller jobs. So that's probably not too far off.
So a couple of things maybe to help us kind of, one, it sounds like, and so let me see if we've got consensus at least among the court, that regardless of what we do with the building, is there consensus that we need to fix the sidewalk? Because that was...
Yes, definitely. And is that, do they really go hand in hand, or is the sidewalk project wouldn't be hampered by not taking the building down at this time? Or?
From my perspective, they are. So strictly speaking, no. You could decouple the two of them and build your sidewalk. But as a practical matter, I think it makes some sense to. The problem with doing that is if you don't grade out your sidewalk, then you're to match whatever you're going to do on the piece of property you have. Anything you do with it, you're going to be kind of constrained by the sidewalk, and it's going to be wrong. You're also right up against the sidewalk. And so I don't remember on that. I think part of the proposal, there was some surveying services in there, but how and where we do that sidewalk would make some difference too, and where we put the curb, that kind of thing. But I think it does make sense to do it together. I think it would be, you might end up replacing that sidewalk again, I think, if you didn't do them together, if you were ever to reuse the property. I think there's a good chance of that. Or you'd be mad that you had the sidewalk there that you were working around, one of the two.
Right.
Jeff, would you put the sidewalk around all three sides, or would you do parking?
Oh, I would only do the sidewalk, I think from the city's perspective, or what the city requirement would do would be the two sides, right?
Okay, on the
There's
street.
two public ways, the one to the west and there's one to the south. And then as far as drainage goes, there actually is a storm drain. That's one of the few places in town where there's a storm drain to get to. So if you were going to grade the parking lot out, you'd probably do some pipe work to get water into that storm drain off-site, or you maybe would drain it out into the street. I'm not sure how you would do that. And then the other thing on the uphill side is that the city's water, the water from the city, I think generally some of it drains onto that site. So you'd have to manage that. So you'd have to grade it out or somehow get it so it goes to the public way. Or there's actually, we put in a catch basin associated with the library, and you might get the water, try to get the water, make a more deliberate effort to get the water into that.
So at this point, we have the projects are separate, because what we're talking about today is just, do we want to go ahead with the demolition of the building? So if we do decide that, yes, we do want to go ahead with the demolition project, can we tie the sidewalk project to that as well, or?
From my perspective, you can. That's completely up to you.
Okay.
Yeah, there's no reason you can't. And you could treat them as separate projects as well, but I think you should do the demolition first.
And Jeff, your proposal though, that fee looks at both, does it not?
It does, that's correct. Yeah, I had one fee in there for just doing the demolition on it. And then I had some additional fee in there for doing the civil engineering. And I can't remember if I included, I had somewhere in there, I had a budget to do some surveying in there as well.
Yeah, there is. So what are we thinking about the building, ladies? Because that seems to be the key decision.
Right? And I think we should go ahead and clean this up and take care of it. It's been on hold for way too long, and I think it's time to make a move.
Yeah, that's kind of where I am too. I mean, I think that unless we had a grand plan to actually use the building that's standing there, to me, just at least getting it cleared and flat gives, whether we come up with a new idea for another building there, whether it stays as parking, or whether, you know, somebody comes in and decides that they could really use a lot to put up a new business or office building or something, it seems to me like it's more usable potentially to future development if it's clean.
Definitely.
That's kind of what I'm thinking. What do you think, Leslie?
Yes, I think it's probably time to do something with it as well. There's a lot of stuff in it. The last time I went and took a look at it, there was a lot of stuff in it. I was wondering how we were going to contact whoever come get their stuff.
Who belongs to the stuff?
I don't know.
So some of it is county, like old office furniture and things like that. And where we get further down in the agenda talking about a surplus policy, some of that we can probably surplus and go ahead and let go. And then the library has used some of that off and on for storage of like books for their book sale and things like that. So, but given probably the timeline of this, Jeff, I mean, we're probably talking about next spring or summer, aren't we?
I think you could probably do the demolition whenever you wanted to do it. But as far as doing the rest of the grading and the other sidewalk work, yeah, that would probably next late spring, summer work.
Okay. So it would give us some time to get the building empty is what I'm saying. We could.
Right.
Okay, I wasn't sure about, you know, and Dewey's schedule, if Dewey's going to be involved in, you know, some of the work there after the building is demoed. You know, what time of year is good for him?
Not
Yeah.
grading season, right?
Yeah, I don't know if they ever have an unbusy season these days.
Maybe
but-
not.
He just has to carve out a spot.
Okay.
So it sounds like, oh, go ahead, Jeff.
Well, I was going to say, I think if you were going to do that, I think we would kind of come up with a plan about what we were going to do. And then we go to the road department and say, okay, what part of this do you want to do? And when do you want to do it? And then we would kind of schedule around that.
Sounds good.
Okay.
Okay. So it sounds like we have consensus on moving forward with demolition of the building and fixing the sidewalks. Do we want to move forward with approving Pillar Consulting's project management? I don't know about you, but I don't know anything about taking down a building or building a sidewalk. So I'd prefer to have somebody manage it for us.
No, we definitely need that. And I move to approve the project management and design services proposal from Pillar Consulting Group, LLC, for the Holland and Sons Warehouse demolition project. And should we add the sidewalk rejuvenation as well?
Okay. Is there a second?
Second.
Okay, it's been moved and seconded that we approve the project management and design services proposal from Pillar Consulting Group, LLC, for the Holland and Sons Warehouse demolition and sidewalk rejuvenation. Is that what you said, Sherry?
That was my word. Did you like it?
I liked it. Good vocabulary. Is there further discussion?
Do we want to put any price on this motion?
I mean, I think Jeff gave us an up to, right?
Yeah, I think for the proposal, I think we have fee in that. I think as I understand the motion, it's just for the design services at this, design and project management services at this point. So the building, the actual works later on, right?
I think so.
Once we
Is that what
get
we're
there,
saying, guys?
find out what it's gonna take.
Okay. So it'd be that 6,940 figure. Is that what we're looking at, Jeff? Do you have that
No,
in
I
front of
think, just a second here. I think there's more if we include the design work in there. Hang on a second here. Can you tell me what proposal number that is by any chance?
It is, let me see if I can.
Be in the lower left-hand corner on one of the
Lower
pages.
left. It's a P 2020-059.
9.
Is it the $11,500 number?
One moment. So what I broke it into two pieces. So I had 6940 for the demolition management, and then that was for items A through D, and then I had 11,500 for E through I. So those were added together.
Okay.
And if you do them together, there's kind of some synergy associated with doing them both together. And that did include, yeah. Yep, and that included survey services, $2,800 of survey services, which you could and probably should hire Armstrong directly for that, because I'll mark it up, so.
Okay.
Okay, so we're clear.
Yeah, so the total amount for both services would be 6940 and 11,500, which would be 18,440. And typically, my experience has been on the demolition ones, I usually overestimate on the demolition side. And that's, I'm just saying that like on the, we did the Gilliam County, the caretaker house, we demolished that one, we were high. And I think we did a couple of other demolition projects. So I suspect it'll come in, if everything goes well, it should come in significantly less than that. That portion of the work should probably actually be around 3,000 if everything goes smoothly.
So this is the worst case scenario number.
Well, I had it as I think I had it as a not to exceed number, or it could be treated as a not to exceed number. So, you know, and when I do these things, it kind of, we're going to put the thing out for an RFP. You know, and it makes a big difference on my part, assuming we keep it simple and everybody gets their stuff out of there, right? We're not sorting things out. And then if we get a good contractor, things go smoothly, I'm not involved much, not that much fee, things get, if you don't get a good contractor, I get more involved, it takes more time. So that's why there's a wide range there.
Got it. Got it. So is there further discussion? If not, then all those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, Jeff.
Thank you very much. Sorry I wasn't paying attention.
That's okay.
Have a good afternoon, bye-bye, or morning, bye-bye.
Bye-bye. Thank you. Okay, we'll move on to 6.4, which is discussion regarding Port of Arlington joint meeting moderator selection. So just to recap, to keep everybody up to date, the last time this came up before the county court, we discussed the port had asked that in order to provide, to allow public input, they wanted to have a moderator sort of managing the meeting. And so I had sent a letter to President Wilson at the Port Board saying that we would agree to having a moderator and asking for recommendations for candidates that they felt comfortable with. So that was back in August. In late September, on the 22nd, I got an email from Kelly over at Port of Arlington, their administrative assistant, proposing two names, Mike MacArthur, who's the former Sherman County judge and former executive director of AOC, and then obviously Judge Pryor, who's the former Gilliam County judge and former president of AOC. And so the question I wanted to get some feedback from you guys on are whether either of these names are ones that we would like to accept, or whether we would like to offer an alternative option. And so in your agenda or in your briefing packet, one of the possible suggestions could be Six Rivers Dispute Resolution Center. This is a group based out of Hood River that provides community mediation and facilitation services to the 7 counties that are along the Columbia River Gorge, basically, so including us. And so I just wanted to get your take on which direction you wanted to go with, if you wanted me to find some alternatives, or whether you wanted to accept one of the two that the port proposed.
I'd like to see us look for some alternatives.
Okay. What do you think about?
Oh, I'm sorry.
I was going to say, what do you think about Six Rivers, Sherry?
Yeah, that sounds good. It's their business. It's what they do.
What do you think, Leslie?
Have we used, well, I'm just wondering, has any of our departments or anything used them recently for anything?
Thankfully, we haven't had any disputes that needed resolved. I will say their background, they actually, way back when, I think this was sort of the brainchild of Judge MacArthur, way back when, that local communities might need this kind of a service to be able to work through and collaborate together on areas of joint interest. And so I think they're pretty well respected. They certainly would come in without, I mean, I think the downside of them was they would come in without really any prior knowledge of any of the history between the two parties, but that may also be one of the plus sides, is that they would come in completely with fresh eyes. And so I don't have any feedback in terms of people they've worked with or things like that, but they seem to be, you know, sort of, this is kind of their wheelhouse, is to facilitate these kinds of discussions. So thoughts on that? Are you thinking, Leslie, on an alternative or accepting one of the two? And if an alternative, do you feel comfortable with Six Rivers, or do you want me to bring back some more options?
You know, I wouldn't be opposed to trying Six Rivers.
Okay.
Unless Sherry wants to, unless Commissioner Wilkins wants to hear some other alternatives.
No, I think Six Rivers is, that's, you know, that's their business, what they do. So I think a neutral party is going to be important to me. Someone who hasn't had any history with actually, some of these names are pretty deeply ingrained in the actual what happened. And
okay. So what I will do is I will go ahead and follow up with communication to President Wilson, suggesting Six Rivers as an alternative. And then I'll also make a preliminary inquiry of Six Rivers to find out who the contact is and sort of figure out how to connect them to the port as well, if they're interested in talking to them before they make a final decision. And so we'll just wait to see what they say back, I think, and I'll just keep bringing this back up whenever I hear back from the port about next steps, if that works for you guys.
Okay.
Sound good?
sounds good.
All right. Let's move on to new business. This is 7.1, our COVID-19 update. And Mimi McDonald is joining us today. I'll give her a minute to come back on.
I'm sorry. You know what? I have to leave right now. I put in the chat I needed to leave by 10:55. So I apologize, but I have another meeting that I have to go to with the OHA. So we'll reschedule.
Okay.
And I will talk
Next
to you guys
time.
later. Bad
So
timing.
sorry about that,
Bye.
Mimi. We'll catch you next time. All right, so we'll move that on to the next one. Sorry about that, guys. And we'll get a COVID update next time. All right, let's move on to 7.2, which is discussion regarding Norcor CARES Act funding subgrantee request. Sherry, do you want to cue this up or do you want me to?
You can go ahead. I'm actually communicating with Molly right now, hoping maybe she would pop on here. I'm giving her the phone number. She said Sherman County was trying to contact us when we were in the middle of something else. So
Yes, I did get a message from Sherman County, but we were right in the middle of a discussion, wanting to know if we wanted to join in and hear their presentation. But I said we were talking about old building demo.
Important stuff. So I'll kind of cue this up, and maybe if Molly joins us, she can fill in any gaps. But so this is just as background for the public and obviously for the commissioners. So we have several streams of funding that are available to local governments in response to the pandemic. Norcor, obviously, with the extra precautions they need to take to keep the virus out of the facility, has seen increases in their costs, basically, to be able to meet all of those requirements to keep that community virus-free. And so one of their avenues for funding is through FEMA. FEMA reimburses agencies 75% of the cost, but it requires the recipient to provide the other 25% match. And so the Norcor board is asking that we consider helping to provide that match through our CARES Act allocation. So the CARES Act is a separate federal allocation, came out of the CARES Act in Congress, was given to the states, and then each of the counties has a certain allocation. So we've got, we've used it to help offset a number of expenses that we've had internally related to the pandemic. And so in essence, what Norcor is estimating is through the end of the year that they would need about $79,000 total, split between the 4 partner counties, to meet that 25% match for the FEMA funding. And they're proposing that that split be based on the current funding formula. So currently, Wasco County pays 50%, Hood River 40%, and then Sherman and Gilliam each 5%. So based on that formula, we would be looking at paying just shy of $4,000, so $3,950. For reference, we have about $140,000 left in the CARES Act allocation. So basically how that works is it's reimbursable. So as we have, when they open, the state opens reimbursement periods ever so often, and so then we submit for reimbursement all of the expenses that have been incurred since the last reimbursement period. And so that would be basically what we would help do. It would be a pass-through through us to Norcor to cover, to help cover this match. So, and I see Molly's joined us. So Molly, I just gave them kind of an overview of what we're talking about and the FEMA funds versus the CARES Act funds. So basically, I think commissioners, what we're looking for is some direction on if this is something you're open to. Obviously, Molly's here to answer any questions about the specifics. I'm just giving you the overview. And then if you were game for this, we would run this sub-grant agreement through legal counsel to make sure that Christy's comfortable with it, and then we would bring it back probably, we could probably get it turned around actually at the next court meeting if this was something we wanted to move forward with. So any thoughts on this or questions of Molly? Well, we've got her.
Molly. So I see that you have said that Hood River County has voted to grant their percentage of the funds, and Sherman County and Wasco County are considering it today, as we are.
Morning, Judge Farr. Molly Rogers, and I'm the designated juvenile director for the oversight of NORCOR. And yes, in fact, we were on the phone or on Zoom with Sherman County just a little bit ago, and they have also agreed for us to kind of finish up the draft and changing out the word Wasco County and putting in Sherman County and having it. So they have agreed to it as well.
Great. Questions for Molly or thoughts on whether to proceed? I mean, from my vantage point, for us at least, it's a fairly small amount of contribution. So, and we have plenty of allocation remaining. So I don't have any concerns about it, but I wanted to raise it with the two of you as well. What do you think, Sherry?
Oh yes, I believe we need to make this support for NORCOR, definitely. Thoughts, Commissioner Weatherall?
I am good with it as well.
Okay. So Molly, what I'll do is I already sent over the initial draft with the Wasco County to our county council, and she had some initial feedback. And so I'll just circle back with you with some of the suggested edits that she had. And then hopefully we can come to a agreement on language, and we'll get it back on the court's agenda for final approval.
Perfect. I think from the draft I sent to you, Wasco County also had some edits, and I will probably not be surprised if they are the same edits.
Perfect.
So thank you so much.
Of course. Any other questions or things to wrap this one up?
I don't think so. Do we need a motion or?
Nope, we won't need one until the agreement actually comes back.
Okay.
So I'll get that squared away and we'll get it on the next agenda.
Sounds good. Thank you.
Thank you.
All right. Thanks, Molly. Thanks for jumping on. Good to see you.
Good to see you.
Okay, guys. 7.3 is consider approval of resolution number R 2020-30, a resolution declaring county vehicle as surplus equipment. I've got a whole mountain of paperwork I'm trying to organize here. Okay.
Yeah, me too.
So, so this is another request from the Sheriff's Office requesting the county court declare the 2004 Toyota Sequoia as surplus. The vehicle was previously used for the inmate work crew, so it has been put through its paces. It has 185,193 miles on it. It's 16 years old, and the sheriff believes that it has served its useful life to Gilliam County, which sounds like it has. I haven't looked inside, but I can only imagine. So the sheriff is asking that we go ahead and declare the 2004 Toyota Sequoia as surplus and sold via the online public auction site, Public Surplus, with a minimum bid of $800. The resolution captures those details as well. So if we wanted to move forward, we just need a resolution or a motion adopting the resolution.
I move to adopt resolution number 2020-30 as presented.
Second.
I knew what you meant.
Pirate Day.
It's been moved and seconded that we adopt resolution number R 2020-30 as presented. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? The motion carries. Okay. Now we are going to enter into Policy Palooza. It's going to be super fun. So let's go on to 7.4, which is consider approval of resolution number R 2020-32, a resolution adopting a risk management policy. So I'm just going to kind of give some overview first before we get into the specific policy so the public knows what's going on, what we're up to. So one of the big initiatives that we're taking this year is doing a major review of all of the county's internal policies and procedures. And so what this consists of is basically looking at all of our existing policies, asking if they're up to date and legally sound, fixing those that are not, and then creating new policies where there's a gap, where we need to have them in place. So each of the policies that we're about to discuss, which there's a whole ton of them, has been reviewed by me, the Chief of Staff, either legal counsel or CIS, depending on the nature of the policy. And then the entire elected officials team has given their feedback as well. So they've read it and given their insights to make sure that the policies are things that they can implement within their department, so that we're not accidentally saying or doing something that really runs contrary to what they need to do from a business perspective. So moving forward, the plan is, because I really don't want us to ever get in the situation again where we don't have any updated policies and procedures. So the plan is that every year around this time that the Chief of Staff, Lisa, in her HR role, will facilitate an annual review of all of those policies, just to make sure they're still meeting operational needs and that they're in compliance. We'll have a new collective bargaining agreement this time next year. The legislature will meet next year. So just making sure that those policies are keeping up to date with changes that are happening either in state or federal law or with any contractual obligations we have with the union moving forward. So I just wanted to kind of put that on the radar, that the idea is that this will be an ongoing process. So the idea is, as we enact these policies, I'm sure, I am positive there will be situations that come up that we missed, that we didn't anticipate in the policy. And so Lisa's role will be basically to keep track of those throughout the year. And then this time every year we'll work to strengthen those policies, basically. So with that, the first policy up is the draft risk management policy. The purpose behind it is to promote a safe and productive work environment for staff, volunteers, and the public. Focuses on early identification, prevention, training, mitigation of all risk exposures through progressive risk management. This was one that CIS flagged for us, as we did not have one in place, and they strongly recommend that we have one, that we have an apparatus basically to make sure that we are proactively thinking through areas of risk and taking steps to prevent or mitigate risks, so that we have fewer insurance claims, lower insurance premiums for our taxpayers, those kinds of things. So, so with that, I'll open it up to any questions or concerns you have about this one.
This was one of the few that I didn't have any questions or concerns on.
And I have no questions or concerns either. I'm glad to see we've gotten it taken care of. So I think to adopt resolution number R 2020-32 as presented.
Second.
Okay, it's been moved and seconded that we adopt resolution number R 2020-32 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, so that is the first one. Second one is consider approval of resolution number R 2020-33, a resolution adopting a volunteer policy. So this policy is designed to make sure that we're connecting community members who want to serve, want to volunteer, with opportunities within the county. It provides some clarity on what volunteers should expect during their service. And it also ensures that we're providing a safe and healthy workplace, both for our volunteers and for our staff. This was another area that CIS noted that we did not have a volunteer policy in place. And given the number of volunteers we have, particularly with like transportation, strongly recommended that we adopt one, again, to reduce potential risk and limit claims and reduce our insurance premiums. So questions about this one?
Well, my first question is, did we have any volunteers who weighed in on our policy, or someone from the transportation department who has the most volunteers?
Good question. I did not run it by volunteers or by Marla, but that's definitely something we could do. She has, I think, a more lengthy, in addition to this one, she has one, a transit-related one, I think that ODOT requires of her for her drivers. So I think she has some additional, because of their training requirements, I think hers is a little bit more robust than this.
Okay.
But I'd be happy if the comfort level would be higher to run it by some volunteers.
Commissioner Weatherall, you have the floor.
What do you think, Leslie?
Well, I had a couple of questions. Sherry or Commissioner Wilkins, struggling. Do you want the Transportation Department or any volunteers to take a look at it?
Well, I don't know. I guess that, like you say, they might have some extra stuff they want to, or questions about the wording, or, I'm just concerned about who it really pertains to, if it's something that maybe some of our more robust volunteers who spend a lot of time wearing different hats might give us some insight that we're not aware of.
Mm-hmm. Yeah, I would be perfectly okay with that. One of the questions that I had was the part where it said that it's okay for staff in another department to volunteer. In the past, when I've run into that same situation, we've always kind of shied away from having staff volunteer in another department, because there might be, they might feel pressure to do so. But CIS or attorney, they're all perfectly okay with allowing staff from one department to volunteer in another department within the same county?
Yeah, they are okay with that, as long as, and I think there's some, let me just find the language really quick, that, yeah, as long as we have written in there, one, it has to be outside the employee's normal work duties. So you can't volunteer for something that you would normally be paid to do. And then making sure that they know and sign a waiver indicating that the decision is voluntary. So that is up to them on whether they want to do that. So one example might be if you had an employee who, for instance, was volunteering to sit on a board. Would you allow them to sit on a board or not in a volunteer capacity? So they would, in that case, be raising their hands and asking for an appointment kind of thing, and then signing a waiver basically saying they understand that it's not part of their duties. So if there was a county board that somebody wanted to serve on, allowing like an employee to be able to do that might be an example of that. I think for most of our employees, they're not really going to be volunteering because most of the business is happening when they need to be at work anyway. If that makes sense. So a lot of our volunteers.
Yeah, the example I was thinking of is somebody works a 4-day work week. They're off on Friday and transportation needs a volunteer driver. Somebody would step up and do that outside there, from maybe the assessor's office or the clerk's office or something.
Yeah, exactly. That would be, those are probably the most prevalent examples would be either a transportation driver on a not work day or a board appointment. So does it, any more questions?
Would we have a problem with that particular scenario if we already have an employee that drives for the transportation department that's not really in the transportation department and gets paid for that time?
I mean, it's certainly worth talking about. I think the difference is we've made that part of his job. That's part of the expectation. There was so again, any of our other staff have no obligation to volunteer. If it's not part of their job, obviously there's nothing they can decide whether they want to volunteer their time on a, on a Friday or on a weekend or something like that if they wanted to do that. So I think there's enough. The fact that we're not asking that particular employee to volunteer, it's actually a requirement of his job, probably is the distinguishing thing there, that there's an expectation as part of his compensation.
Okay. It talked about job descriptions for each of the volunteer positions, and I'm wondering who is going to be responsible for preparing those.
Good question. I think probably what will happen is that will be a collaboration between the department head that needs the volunteer and human resources, Lisa in her capacity as the human resource person to help put those together. I don't think they have to be as robust as the job descriptions for our employees. So I think it probably still needs some of that language about what the work environment would look like and things like that, just so people are aware of that when they're volunteering and can make an educated decision about whether that's a good fit for them, both from a physical standpoint and from an interest standpoint. But that would be my anticipation, is that would be a collaboration between the department that's overseeing the volunteer and HR.
Okay, I didn't have any more questions on this one.
Okay, so would you guys like me to run this by Marla, or what would you like to see for next steps?
Yeah, I think some of our more active volunteers, maybe if one or two of them took time to read through it in case they had any of these same types of questions, or maybe clarification of something, might be good to before we sign it in.
Okay. So I will do that follow-up over the next week or so, and then I will get it back on the court's agenda with any, if those volunteers have any feedback, suggested edits. That works for everybody?
I like it.
Okay, sounds good. Let's go on to 7.6. This is resolution number R 2020-34, a resolution adopting a fleet safety and use policy. Again, this is designed to promote safety in the workplace, particularly with the safe operation of Gilliam County vehicles or personal vehicles that are being used on Gilliam County business. This is another area that we did not have a policy for, that CIS strongly recommended that we adopt one, particularly given the number of people we have that drive for county business. So with that, I will open it up for questions about this one. This one has a lot of
questions. Go ahead. Go ahead, Commissioner Wetherell.
So do you want me to start, or?
Yes, please do.
Let me say I am anticipating that most of what you will bring up was probably brought up with the elected officials. So bring it on, whatever you've got.
Probably. Now this one in particular, who was the legal, did the legal counsel review this, or was this one of the ones that it was just CIS?
This came from CIS's folks and was reviewed as well by John Anderson on the insurance provisions. Where it mentions any insurance, he looked at those as well.
Okay, but not Jeremy or Christy or?
Not Jeremy or Christy, no.
Okay. Okay, the defensive driving class every 3 years, that's a condition to even be able to drive your own vehicle to a meeting or something like that. Like if Commissioner Wilkins or I have to go to a meeting in the Dalles, we have to, looks like every 3 years you have to participate in a defensive driving class. Is that what's entailed in the driving class?
We haven't had one in years, so I don't know. It's been, I think Chris Fitz was saying it's been quite some time since they had it. But they're, I mean, basically they would, I think we're talking about maybe a couple of hours every 3 years for them to just update on basically defensive driving, traffic laws, things like that, things to be aware of. Any changes to, you know, traffic laws since we all got our licenses, you know, those kinds of things. So
I was just wondering if it was something that was like a in-person type training, or was it a thing you could watch on the internet, something like that? Because if it's only held, just, you know, depending on schedules, I was wondering if somebody missed it, you know, how easy it was to pick up a training. That's the only thing I would, I guess, be concerned about, how easy it is to pick it up if you can't do it on the day, if it's an in-person type training.
So likely what we would do is we would have at least a day for sure that we would try to encourage most people to go to, but then obviously have a makeup option if you're not able to make it, just because it isn't feasible to have 55 people, which is the size of our workforce, all in the same room on the same day. That I don't see that happening. So the idea would be that if we put the policy in place, basically part of Lisa's role as human resources is to come up with that training schedule and keep track of who has it and who needs it. And so could work with individual employees who need it, you know, who need that refresher, and giving them some options in addition to the in-person training to be able to meet that qualification.
Okay.
Can I say something?
Yeah, go ahead, Chris.
So, yeah, so John Zacharias is the last person that came to Gilliam County and did that. And we actually had it upstairs at the City Hall years ago. And then Sherman County had him scheduled to come. I think it was just within the last year, and I put it out there. And I don't think anybody from Gilliam County was able to go to Sherman County. But what I would almost suggest, if they are only doing it in person, is to give it a 3-day schedule and have as many as maybe 15 to 20 people at each time, because, and then we could, you know, spread apart if that's the case. But also because I think you're also looking at the volunteers for the senior transportation, having to potentially have that class as well. And the last one we did take in person, high emphasis on using the cell phones while driving. It was back then, that was when cell phones were, you know, coming out, and a lot of the texting was just new. And so he had a really high emphasis on the texting while driving and putting your cell phone away. So that's all I can tell you right now.
Thank you. Okay.
More questions?
Yes.
What's next, Leslie?
As I got into page 2, I was just concerned that this might be a little too restrictive. There's a lot in here about driving situations that might have it on our employees' own time. So I just was worried about you know, them having an incident of driving on their own time, and then that precluding them from being able to go to a meeting, even in their own rig. You know, I'm not as concerned about saying, you know, fine, you can't drive our county rig because you had some infractions on your driving record, but to not even let them take their own vehicle to a meeting. I was concerned about this. Some of the minor violations, you know, having more than 2 minor violations in the previous 3 years. I just looked at this at a couple of these. I think you could get a few of these in the same incident if you had a mishap. And so I was just worried about it being, you know, for people that work in the office, not for people that, you know, driving is a full-time requirement of their job, if this was too stringent.
Yeah, that came up definitely. I mean, that was a big topic of discussion when the elected officials reviewed this as well. This was a concern that they had raised. I mean, one of the things I think we're struggling with, and I kind of put it out to the elected officials as well, and we didn't come up with a different answer. I mean, we weren't sure how to address it, is how do you decide how much is too much, right? So like if there's a pattern of behavior of someone who is driving unsafely and they're driving on county business, even if it's in a personal vehicle, that presents a liability for the county. if they have a pattern of behavior of being on their cell phones kind of thing. So how to sort of get the right balance between understanding that, to your point, like somebody may have one incident where there's several violations, how to distinguish that between a pattern of violations, basically, where that may show unsafe behavior and maybe they shouldn't be behind the wheel if they're continuing to, say, speed, use their cell phone when they shouldn't be, driving distracted, those kinds of things. So I think this is definitely an area, if we wanted to adjust the number of violations, I think we could definitely do that. But I would just caution that we want to make sure that we're not allowing somebody who is repeatedly exhibiting unsafe driving behavior, whether in their own vehicle or not. Because realistically, if they're getting caught in their own vehicle, they're probably doing it in county vehicles too. They just haven't been caught. So that's my only cautionary thing, is that I think we need to be careful about striking the right balance as far as how many is too many, and how do we make sure that we're not inadvertently putting somebody behind the wheel that could cause a serious accident or injure a member of the public that we're transporting or something else. So what do you guys think about?
I'm concerned with that too. I just think that this, you could do an improper lane change and, a failure to yield the right of way. And you could do, like I said, a couple of these all in one session. So I just felt like 2 minor violations in 3 years. I just thought it was too many. I mean, I thought it was a little too strict.
Okay. Is there a number that you would feel more comfortable with? This is the hard one.
I don't know. But okay, so just because I want to muddy the water a little bit even worse, even like a major one, like a DUI, say someone on the weekend goes and has 2 beers at their friends, and for someone of a certain weight without food, that could be enough to put them at the 0.08. And so at that point in time, though, if somebody does get a DUI, somebody that just works in the courthouse, or say as a elected or whatever, then all of a sudden, then they're done. They just cannot even drive. Once they get their driver's license, say they have their driver's license removed for 3 months or something, they get their driver's license back, but they can, they could get fired, or they can't drive to meetings anymore, or I see this happening. I see this happening to people, and I'm just wondering how we will actually handle it when it does happen to one of our actual people.
So most likely what would happen, to your point, yes, if somebody, the issue, if somebody got a DUI, for instance, and one of their job requirements is that they have to be able to drive, like the road department's a good example. They have to have CDLs. DUI would mean that they lost their CDL and their license. That would likely result in a termination for that employee because they can't perform their job duties anyway. So it wouldn't be an issue of getting their license back because they wouldn't be an employee anymore at that point. Sheriff's office, I don't know for sure, but I'm guessing Chris would tell us that the sheriff's office has a zero tolerance for that as well, that somebody gets a DUI, that deputy's being fired, basically. So for the rest of our employees, though, again, these are pretty major violations. And so really all we're talking about is saying, if you get one of these, you don't get to drive on behalf of Gilliam County anymore. Basically that privilege is suspended. In part because, realistically, if we put somebody who we know has a DUI behind the wheel driving some of our seniors to their sites, and they are, to their appointments, and one of them gets into an accident and God forbid, kills somebody, that's a huge liability for us to take on and say, yeah, we knowingly put somebody who has a history of driving while impaired behind the wheel.
Well, I feel that's a little too strict. I feel like someone can make a mistake in a situation on their own time. It does not affect their ability to drive when they're at work. So I was concerned about that. To me, that's a little too strict, and maybe I'm the only one, but.
Sherry, what do you think?
Well, I feel like, if these are driving laws of our state and that influences what happens to their driver's license, then that influences what happens to their driving privileges as well. But I tend to lean towards stricter policies than some others.
You do that, you do. Okay, I want to bring up some of these things because I won't, I just won't feel good if I don't at least say, what about this? I just look at, some of our really good employees, and if they make a mistake on their own time and and they're not someone that drives for a living,
Yeah, I think the danger
I hate to see us get pigeonholed in a certain response because of what's in the policy.
Yeah. And keep in mind, like, it's within 3 years, and so that rolls off, once it clears their record, basically, once it clears that 3 years, then their driving privileges are reinstated. But most likely what would happen, to be honest, is we would tell those people that need to go to meetings, you either need to be the passenger and go, if an entire office is going, then you're the one that's not driving. Basically, you're the passenger, or you're participating via Zoom until you're, until you have driving privileges again, basically. That would be sort of the practical thing. But I mean, it comes up pretty rarely, I would say. I definitely, though, I think on the major violations, those are pretty serious things for people to, we're talking about leaving the scene of an accident, reckless driving, road rage kind of things, a DUI that for other employees would make them lose their job entirely, not just revoke their driving privileges. But I definitely, if you want to look at the minor violations, if that's something that would help you feel, for those circumstances where somebody maybe has, multiple ones in one incident kind of thing. Somebody's in a hurry and on their cell phone and forgot their seatbelt, or, whatever it is. That could be something. Keep in mind that the matrix below at the bottom of that page has like up to 3 is borderline. And so I think that allows some leeway for the supervisor to look at this actual circumstance of the situation and decide, like, if this is a one-time incident and 2 of these things happen at one time kind of thing, that it's not necessarily just an automatic. Those sort of borderline areas are kind of the areas where the supervisor would have a little bit of leeway to look at and say, in this particular case, and one example that came up, and this is probably the most common one, is on the accident side, is how you deal with like somebody who hits a deer. Does that count as an accident kind of thing? And where we landed with that is that the safety committee is really charged with looking at all of the accidents that occur in county vehicles to determine whether they could have been prevented or not. And so they will sort of make that determination based on the circumstances of the accident. So if it's something like a deer jumping in front of your county vehicle, that's obviously going to be treated probably differently than someone who was speeding and slid off the road and rolled the vehicle, as an example. So hopefully there's enough kind of leeway in here to allow supervisors and the safety committee to take into account the specific circumstances of what actually happened. That makes sense.
Okay, so per department, because I've been wondering about how this works with the electeds and their own departments and their employees. Is each department and each, elected, are they going to be responsible for the interpretation of this if it happens to one of their employees?
Yeah, I mean, ultimately, it'll be up to each of the elected officials to determine how this applies to them. So they would have some leeway within there to look at the specific circumstances. Again, the accident review happens as an automatic course through the safety committee. That's part of what they're charged with, is to figure out, was there something that led up to this accident that could be prevented in the future? So their role is going to be looking to see if this was an at-fault accident or not, and that will help inform the supervisor potentially on how they want to handle it. But the idea when we talked amongst the elected officials was they wanted that flexibility to be able to look at the circumstance with their own employees. Most likely that will result in a, if they decide to take action and revoke privileges and things like that, that'll be a conversation that obviously needs to happen with CIS as well. As HR to make sure that we're following a consistent process and procedure. But a big reason why all of these got reviewed by the elected officials is I thought it was important that we have buy-in from all of the departments up front and have similar expectations for employees, so that one department doesn't just say, forget it, I'm not bothering with this, and another department is doing it by the book kind of thing. So that's why we've had a lot of meetings amongst the elected officials to go over these sort of section by section and try to address any concerns that came up.
Okay.
More questions?
Okay, so on top of page 3, it talks about driving records will be ordered every 12 months for all employees. That just feels like an invasion of privacy to me. I don't know. I read that and it kind of jumped out at me like, but maybe I'm wrong. I struggle with that one just a little bit too.
So here's what the impetus of this is, and then we can decide whether this makes sense or not, or whether even the 12 months makes sense. But right now, the way that we do this is when we hire somebody, we check their driving record as part of their background check, particularly if they've got a requirement like a CDL or things like that. Then we never touch it again. So if the employee goes out and has something where their driver's license is suspended and they're in another county where, our sheriff's office is not aware that this has occurred, and nobody checks the driver's license on a regular basis, we have the potential that if the employee doesn't say anything to us about having a revoked license, we could potentially be putting people behind the wheel that are not legally able to drive, or that have a pattern, they've received multiple infractions that might lead to them not being able to operate a vehicle safely, As an example, some of our elderly volunteer drivers might be useful to be able to check and just make sure that they still have valid licenses before we put them behind the wheel. So that's really what this is getting at, is this idea that, for some of our folks, they've worked for us for 20 years and we've maybe only checked their license when they were first hired. And so ensuring they still have up-to-date credentials and things like that is just is part of what CIS, honestly, and our insurance agent recommends happens, so that we don't inadvertently put somebody behind the wheel who has a pattern of driving unsafely. But more thoughts on it.
I can see it for the volunteers that drive, and I can kind of understand it a little bit more for the people that job is driving for the county. Most of these I looked at as like people that worked in the courthouse, how this would affect people that just work in the courthouse.
But we're still liable if they get in the car and go to the Dalles for a meeting.
Yeah.
So, and a lot of those people working in the courthouse are getting in county cars, and that's, we're reliable.
Okay, so you don't have any issue with checking everyone's driving records once a year?
I do not. Been it done before in corporation.
Okay. The next section says all vehicle accidents will be reviewed by the safety committee. So that's any accident that someone gets to in their own time, you know, they back into someone in the parking lot or anything like that, they're going to get reviewed by the safety committee if they do it on a Saturday at the grocery store?
So I think this part in particular is referring just to the county vehicles. Because obviously the safety committee, unless the employee reports that they had an accident, you know, if they had a fender bender and they never reported it, it never went through law enforcement, there'd be no way for us to know that that occurred. But every county vehicle accident, those get reviewed
Okay.
by the.
Can we add that? Can we?
Yeah,
put
maybe we
that in
would
that
make
section?
that specific, yeah.
Okay, we can do that. So,
All vehicle accidents involving a county-owned vehicle will be reviewed.
we can definitely do that.
Okay, I'm almost done with this one. The bottom of page 4, you know, I want to ask questions about things if they're realistic. You know, if we're realistically going to do this, I just don't even want to include it in a policy, but it talks about if there's 2 people going to a meeting and the driver is backing up, that the other person is going to get out and spot them while they're backing up. And I just wanted to say, do we want to keep that in there? Because is that really realistically going to happen?
It's not happening now.
It is not. I mean, one of the things the safety committee is working on, and they just implemented, is sort of this 360 check and encouraging that the driver walks around the vehicle and makes sure that there's nothing behind the vehicle before they get in the vehicle. So the employees have already received training on that, and that's sort of the expectation. There's a 360 checklist now in all of the fleet vehicles for them to be able to do that. The sheriff's office, by its own policies, backs in, so it's not relevant to them because they're not backing out, and that's why you see the reference in there to the sheriff's office recommending that people back in instead of pulling in to a parking spot, so that they don't have to worry if somebody's particularly for them, if they're in a hurry about accidentally hitting something, backing out. So, but if you guys would feel more comfortable striking that second sentence, that's fine by me.
Yeah, I don't think that's, people aren't going to do that.
Okay. So shall we strike the second sentence that if there are 2 people, 1 person should stand behind? That one? Okay. I've got that struck. What's next?
Okay, we're getting close. On accidents and incidents, drivers must report every accident to their supervisor without fail, no matter how minor. I'm wondering, do we want to add involving a county vehicle on that?
Yeah, because technically, like we just said, if you backed into somebody at the grocery store and everybody got out and said, oh no, here's my insurance, and, you know, I broke a tail light, and you go on, that's really not reportable to your supervisor.
Mm-hmm. I'm okay with adding that. So we just want to add, let's report every accident involving.
Yes, a county vehicle.
County vehicle.
Could we also add, because some of the language we used earlier was, or a personal vehicle while on county business.
Okay.
Just in case there's a claim that comes out of it. I'm not sure how that's actually treated. I'd be curious to know from our insurance agents, if somebody is on county business and has a vehicle accident, if the county has any liability under that or not.
Be good to know.
Yeah, I mean, you wouldn't think that their car insurance would be the one that had to take care of that? Or we just don't know?
Well, I just wonder if say you're the victim of that or the other party, if you wouldn't try to come after the county anyway, knowing that the county has more resources likely than the individual. That makes sense.
Yeah. That does make sense. Yeah.
Okay, so I am adding under number 1 on that page, drivers must report every accident involving a county vehicle or a personal vehicle while on county business to their supervisor without fail. That way we're just aware if somebody was out driving in their personal vehicle on the way to a meeting and they hit somebody, just so that we have some sense if we suddenly get a letter from a law firm suing us, we know what happened.
Should we just make that whole thing, these rules of accidents and incidents are specific for, what am I trying to say? Because all of these things have to do with whether you're in a county vehicle or in your personal vehicle on county business.
So what we could do is say accidents or incidents involving are you thinking just in the title? We could do accidents or incidents involving a county vehicle or a personal vehicle while on county business.
Yeah.
Okay.
I could do that.
And
Does that work for you, Leslie?
That
Yes.
says that about all 10 items.
Okay.
What do you think, Nathan?
He says, okay.
Oh, okay. No, I think that's a good addition.
Thank you.
Because there is, to Elizabeth's point, there is a liability with them being out on any time that it's technically work time, them out driving any sort of vehicle.
Right.
There is potential liability. I worked for business that got sued. We had an employee got in an accident on the way home from work. And this is one of the reasons that I'm a proponent for a time clock, because they clocked out and they were not on our time. But if they had been, we probably would have had to pay some money.
Yeah.
So
We got to protect ourselves. So, yeah.
yeah.
I think oh, go ahead. I'm sorry.
No, go
So
ahead.
I will add that to the title then. Accidents and incidents involving a county vehicle or a personal vehicle while on county business.
Thank you. I think that was most of my heartburn with this particular policy was how much on your own time was included in the policy, and I just struggled with that a little bit. But that was the end of my comments on this one.
So to go back, the changes that we would be making, Leslie, did you want to make any changes on the minor violations language? I don't think we ever resolved.
Yes.
Okay, so are you thinking, what's the magic number?
Well, I kind of liked, well, 3 would be better for me, but also I kind of liked if you somehow put in there, I don't remember, we were almost there, but something about all-in-one incident. Something that says that, if you keep continuing to do these things on different incidents, yeah, I can say more than 3 would start to show some kind of problem. But if they all happen in one incident that you just, messed up and.
But isn't that part of the review process too, or do we want to make that?
So would it simplify it if we said no more than 2 or 3, whichever we decide, separate incidences or separate incidences of minor violations, just so it's clear that we're looking for a pattern rather than like a one-time, one and done kind of thing? Would that resolve it?
Yeah,
that would help me.
You
Yes.
could get
Okay.
failure to signal an improper lane change and failure to pay a traffic controller signal all in one oopsie poopsie.
Yes.
Yeah. So, first question, do we want that to be 2 or 3?
I like 3.
3. Are you okay with?
Yeah, I'm okay with that.
Okay. So we would do 3 separate.
Minor violations.
Is that clear?
Yeah.
And does that help, Leslie, on your heartburn?
Yes, I think so. If we say separate, it indicates that I mean, is it clear that it's not something that could have happened all in one?
So I could do 3 separate incidences, so it's even more clear.
Okay.
So the language would be no more than 3 separate incidences of minor violations in the previous 3 years. So if you had, say you had 2 separate incidences which both involved 2 minor violations, that would count. I mean, it wouldn't trigger this, in other words, because you've only had 2 separate incidences.
Okay.
This is sort of like a 3 strikes and you're out idea.
Right? There you go. There you go.
Okay, so here are the changes that we discussed that I can incorporate into the draft. Do you want to make the motion and just have these part of the motion, or would you like me to bring this back updated? What's your preference?
I would prefer bringing it back updated.
Okay.
I think that's a good idea.
Okay, so what I will do, I'm going to circle this for follow-up.
That reminds me of something else on page 3 when we're talking about accident review, and it says all vehicle accidents will be reviewed by the Gilliam County Safety Committee. Do we want to say all vehicle accidents involving a county vehicle or while on county business?
Yes. Are you looking under page 3, number 2? Is that what you're looking at?
Yes.
Okay. Yep. And, okay. So I have 3 changes in here. Let me make sure that I've got them all. I didn't miss one. The first one would happen on page 2 under number 2. The new language would say no more than 3 separate incidences of minor violations in the previous 3 years. And I would go ahead and update the driving matrix below so that acceptable would be under number 3, where the borderline is now. That would be acceptable, and then we just move the borderline down to 4, basically. And then on page 3, number 2, update the language to say all vehicle accidents involving a county-owned vehicle or personal vehicle while on county business will be reviewed by the Gilliam County Safety Committee. And then the last one came on page 5, and it's updating the title of accidents and incidents to add that involving a county vehicle or personal vehicle while on county business language.
And
on page 4.
And then on page 4, I just saw that. Let me put a star by it so I don't miss it. And then cutting the second paragraph of the sentence in proper backing, where it refers to if there's 2 people, having 1 person stand behind the vehicle. Just as that's probably not going to happen. We want to be realistic.
Probably not.
Okay. Go ahead, Chris.
So how long does that last when, and the reason why I'm asking is, like, say, for example, I have a public health emergency prepared meeting from 10:30 to 1:30, and I also have a doctor's appointment at 3 o'clock that day. So I've elected to drive my own vehicle to the meeting, and then I'm done with the meeting and I go to my doctor's appointment, and then something happens on the way home. So where do you draw the line that, okay, I took my personal vehicle for a meeting, but then I also attended my own doctor's appointment?
That's a good question.
Mm-hmm.
Good question. I mean, I think, again, that would be up to the supervisor. In an incident like that, the supervisor would have to look at that. So presumably, you would have had to driven home anyway, regardless of the doctor's appointment. So if you got in the accident on the way home, my hunch is that you would still potentially be considered on county business. on your drive home, but maybe not if you're running errands around town. So
right, and we have talked about that, the difference of us taking our own vehicles when we decide, okay, we got a meeting or whatever, and now we're going to go, we've got stuff to do, and so, you know, we write down our vacation time or our sick leave time for a doctor's appointment or whatever it is, and then come home later. So there's a lot of gray material in this, so something to just think about.
yeah, that's a good point. I think it's something that we
considered off the clock.
Yeah. And I don't know that we as the governing body necessarily want to lock in what exactly that means at this point, just to give the supervisor a little bit more leeway in looking at what the specific circumstances are. Because the minute we put something on paper, somebody's going to come up with a situation that is just a little bit different than what we wrote down.
Which is, again, why this committee is reviewing what has happened.
Exactly. Okay, any other changes on this one?
I don't have any.
Okay, so what I will do is I will make those changes and we will put it back on the 21st for final approval.
Okay.
Sounds good. All right. Let's go on to 7.7. This is, yeah, am I on the right one? Yes. Consider approval of resolution number R 2020-35, a resolution adopting a limited English proficiency policy. So this actually came out of a request from Victim Services because April has some federal grants that support that, and she was going to have auditors coming in to make sure she's compliant. And one of the questions they ask is whether we have a limited English policy in place. And so upon further digging, what we discovered is that federal law requires that if you are taking federal grants and monies, that you have a policy in place to be in compliance. And so we went ahead and drafted one, not only to make sure that April's in compliance with her specific grant, but that any other departments that have federal funds coming through them are also in compliance. This was another one that initially caused quite a bit of concern from the elected officials, only because I think there was concern about the need to, say, have to translate all of their documents or things like that. And so we went back and forth several times on some language. I think hopefully we've got to a place now where there's enough flexibility within each department that I think we reached a comfort level with the elected officials in terms of them being able to use this policy in a way that's going to not intervene or interfere with their business activities. Questions about this one?
Yeah, you just answered my question. My question was just, is this policy going to cause any undue hardship on any of our, specific departments?
Yeah, the places where it's most likely to be applied, to be honest, is probably going to be within the sheriff's office, the justice court, and the DA's office. And so all three of those elected officials have looked at it, and we talked through some of their concerns. Initially, the language was much more prescriptive in terms of how they had to meet that need. For most of them, like, for instance, the court system requires interpreters during different times, for instance, throughout that process. So, as I got to talking with Judge Patnode, for instance, quite a few of the things that her staff is already doing just to bridge language divides when someone comes into their office would help meet this requirement, if that makes sense. So somebody comes in and they're clearly not an English speaker. We were talking about, online tools and stuff that will translate in real time and things like that. We have some local people who are fluent who are sometimes asked to come in and help translate documents, things like that. So all of those things would count. So my hope is, I think we've got to a point now where each elected official can really look at the specific circumstance, determine based on the type of service that's being accessed. You know, obviously we want our folks to have fair access to the court system. By law, we have to do that. But then that allows, say, Judge Patnode to look at the resources that she's got available, whether that's local interpreters or whoever that is, and then try to meet that need based on the individual that she's working with or that her staff is working with at the time. So that's why it says, like, when the county identifies a need exists, the county may use various resources rather than saying that it has to be this or that, or they have to translate every document. We just don't, for most of our departments, have the volume to justify the expenditure of translating documents. That doesn't really work for us. So for example, one of the accommodations may be when we can't translate a document, that we have a local volunteer translator who's able to speak with the client and translate what the document actually says, you know, verbally rather than a written translation. Questions about this one?
I don't have any.
Didn't have any more.
Okay. Do we have a motion for this one?
I will make a motion. I move to adopt resolution number R 2020-35 as presented.
Second.
It's been moved and seconded that we adopt resolution number R 2020-35 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, we'll get that one moving. Next one. Oh, we're getting into the really fun ones. So this is resolution number R 2020-36, a resolution adopting a mobile devices, communications, and social media policy. This is one of the policies that actually the county had before when we did our review. So this is an update of that policy. And it's kind of an expansion. Originally, the original policy just dealt with mobile communications devices. So we took and updated that language and then also added some additional language about communications and social media. That language came from CIS's attorneys about just putting those sort of expectations in place.
And did county council look at this one or just CIS?
So I believe county council looked at the original mobile communications one, not necessarily everything that's in here, but sort of the basis that we took it from. But no, it's been CIS that's reviewed it.
Okay. Did you have a whole list of things for this one, Commissioner Webb?
Not as many, but I have a few. Are you ready?
Okay, lay it on me.
Go for it.
Okay, page 3. When it talks about work sites, it says employees are prohibited from using all mobile communication devices while at work site, during which the operation of such device will be a distraction to the user. So do we consider the courthouse to be a work site?
Yes. And I think we talked about this amongst the county, the elected officials as well. This came up, this particular one. Again, this is going to be up to supervisor discretion. So, you know, somebody has their kid text them to let them know that they're, you know, leaving school and going to the babysitters, probably not going to be treated as a distraction. Somebody who's on their cell phone for 3 hours and never looks up every time the supervisor walks by may be treated as a distraction at that point. So the idea is just to give the supervisor some tools to basically say, hey, you know, you're using your cell phone way too much. you're distracted from work, basically, and to be able to provide some accountability there.
On the next page, it talks about, somewhere in here, it basically talks about not using any of the county's electronic equipment, or, you know, something that's, you know what I'm talking about. This is like internet usage type of concerns. And just was wondering, I mean, it basically acted like you should never use your county device for anything that's not. So, so how do you police that, or how do you enforce that, or how do you know if people are looking at, you know, like they have to look up something real, you know, their doctor's phone number or something on their device or computer? How do you?
So we don't do any active surveillance. You know, it's not like we're having Kelly like poll everybody's user usage, you know, every website that they've gone to. So I'm not anticipating that there's going to be like this huge crackdown on, you know, people using things personally. But I think the idea is that when it does come up, the county needs to have the tools that says upfront that this isn't allowed. I mean, it really, for most folks, you have a smartphone, and so if you need to look up something personally and you want to take 15 minutes in your break and go look that up, then that would be the appropriate time to do it. But if you're sitting on Facebook, on your county computer all day, naturally the public wants to know why somebody is showing up and they can see they're online on Facebook all day when they should be at work, kind of thing. So there'll be some of those things where, you know, I mean, we have several departments who have county business to do on Facebook and things like that, but for other employees, they really shouldn't be on Facebook when we're paying them to be working for the public. I think the public probably expects that they not be using county resources to do their personal business, would be my take on that.
Okay.
Sherry, any thoughts on that?
No, I agree. I've been in a workplace where that actually did become a problem. And it does give you that ability to say, you know, that's in the handbook. We've asked you, you know, not to do that. And yeah, gives you some leverage. But yeah, nobody's going to stand around and look over people's shoulders every day to see what they're doing. But if it becomes obvious, then it's a problem.
Yeah. Yeah, it's pretty obvious when somebody's posting on Facebook during their work hours, for instance.
I've seen some posts when I'm scanning where people I think should be working and they're on Facebook.
Exactly.
Not county people, others.
Other questions, Leslie?
Okay, top of page 5, it says employees should lock their computers when leaving their workstations unattended. I was just wondering, is that occurring currently, and what's our concern? What's the concern with having that happen?
Yeah, so it should be a best practice, and that's part of our training that Kelly does when she's talking to the employees about IT safety and things like that. It really just boils down to some people actually have where your computer, if it's idle long enough, it automatically locks anyway.
They're supposed to all be set to lock themselves after it. I think it's 15 minutes.
Okay, I have that. I use that at my job too, but
yeah. But the idea just being, I mean, Nathan and Kelly's office is a great example. If their terminals are left unlocked, they have access to all of the county's financial accounts. So them leaving their office safe, and they have different protocols where they lock their office and things like that, but let's just say they didn't do that and they walked away and they had their terminals open. Potentially somebody could come in and gain access to all of the county's accounts if they don't protect that. And same with like the sheriff's office has access to, and Amy's office has access to what are sensitive state, criminal records and judicial records, those kinds of things. So it's mostly just a reminder to folks that some of the information that we have on our computers is highly sensitive, and that they need to take precautions if they're not in the room with their computer, that they are locking it so that somebody is not gaining access to things that they shouldn't, basically.
Okay. Like I said, I use it myself, but a little bit farther down the page, it talks about email, and it says email should not be used to transmit confidential information. And I was thinking, do we now? Because, just things from attorneys and, certain emails that I've seen have had confidential information in it.
Yeah, and so there's a little bit, I think there's a little bit of leeway there. Obviously, not all confidential information is treated this is equal kind of thing. So like people transmitting like Social Security numbers and things like that that are highly confidential is maybe a little bit different than, say, a memo that came from our legal counsel that comes over, where it may be confidential, but it's not necessarily compromising somebody's identity. But it's just sort of a reminder that none of these systems are fully foolproof. And so our employees just need to take care that when they're sending an email, to be thoughtful about the information that they're submitting, because we could easily have somebody hack into the email system or access, it in some other way, and just making sure that we're not inadvertently compromising information that we're entrusted to protect, basically.
Okay.
But again, these are mostly, I think for most of our folks, it's not something that they would intentionally do. It's just sort of a reminder to be mindful that these systems are not foolproof. And so we all have sort of that obligation to protect the information that we're entrusted with.
Okay. Okay. The top of the next page, it talks about charging long distance calls to the county, and that if you make a long distance call, you can be terminated. Has this been a problem? Has this happened? And I guess I'm just wondering, how is this policed? Is this, just absolutely cannot make a long distance call
And to be clear, that is like a personal call. So like, if you have to make a long distance call for county business, that's allowable. But this is really, this idea that employees may occasionally have personal calls that come in through their landline. Maybe it's a kid that's checking in or a spouse. And that's allowed as long as it's sort of limited. But the idea that you can't turn around then and make a long distance phone call on county equipment. Kelly gets the phone bills and can see where calls, where calls are going, basically. And so she's able to sort of look for any anomalies in those phone bills to see, if we've got, I don't know, if somebody's calling like South America consistently, and that really doesn't make sense for county business, she has the ability to see what's going on. We've actually had situations where people have hacked into the phone system and made calls, and she was able to look at that based on when the calls happened. It wasn't during county business hours, to see that that wasn't an employee or anything like that, and to make sure that we weren't charged for those calls, that those were. So she is able to see the phone bills and kind of look for anomalies. But for most people, they're making calls maybe to Salem or someplace, some of our neighboring counties or states. We probably are not going to see a whole lot of calls outside of the Pacific Northwest. So those that do show up would probably at least flag for her to just take a look and see, make sure that there's not a pattern potentially that may mean somebody's abusing it.
Okay. This is my last question on this one. Did the electeds bring up any concerns about the posting, what kind of things you can post on social media? Was there any conversation about people's posts?
Definitely. Yeah, that definitely came up as a concern to try to just make sure that we weren't infringing on First Amendment rights. This language came out of CIS's attorneys. So it was their pre-loss attorneys that actually drafted this piece, not their HR people. And so basically, sort of the takeaway that I had from it is that there are certain things that even if an employee is off of county time that simply can't be allowed. As an example, if we have a situation in the workplace where harassment is going on and an employee decides at 5:30 that they're going to post something derogatory towards one of the coworker that they're harassing during work, we have an obligation as an employer to not allow that behavior to happen because that impacts the work environment as well. And so that's sort of been the advice that the attorneys have given, is that there's certain things that it really doesn't matter whether you're on county time or not on county time. If what you're saying or doing is discriminatory, harassment, those kinds of things, the county has a right to ensure that all of our employees feel safe while they're here. And so that is allowed for us to be able to restrict some of those things. In terms of some of the broader stuff, really the idea here, the balance we tried to strike is there's a difference between somebody who is acting as a private person and voicing a concern on, say, social media, versus somebody who is representing themselves as a member of the Gilliam County family. So, so this is sort of trying to distinguish that even if you are posting on personal business, but you're representing yourself as a representative of Gilliam County, that there are some restrictions in what you can, how you can portray certain things, and that our employees just need to be aware that that there is a line there because they are public employees. That there's some expectations in terms of how they conduct themselves when they're online, and to just be mindful of that. But it wouldn't, for instance, you know, if somebody is commenting on a matter of public concern, you know, whether it's something that we're considering as a court or somebody else, and they're commenting as a private citizen, those are protected things. So in all these cases, sort of what I talk to the elected officials about is anytime, in practice, anytime this would come up and somebody posted something that a supervisor found objectionable, thought maybe a violation of the policy, these would automatically be referred to CIS's pre-loss attorneys to make sure that the county is not violating anybody's First Amendment rights, that we make sure that we are staying within what's our authority to be able to set boundaries on, if that makes sense. So that's sort of what we talked about, and I think that helps the elected officials understand that it's not just, I don't like that an employee posted something on Facebook kind of thing. There are certain thresholds, and we would involve legal counsel if this ever came up, just to make sure we're not violating somebody's First Amendment rights.
That was all the questions I had on this one.
All right. So no changes to this one, correct?
Correct.
Okay. Sherry, did you have any questions?
No, I'm good. Well, I'm going to take it offline.
Okay.
It really doesn't have to do with the policy, but I do have a question about some email. But I'll ask you offline.
Okay. Do we have a motion?
Okay. I move to adopt resolution number R 2020-36 as presented.
Second.
It's been moved and seconded that we adopt resolution number R 2020-36 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay.
Can I make a quick suggestion?
Yeah, do you want to take a little break?
A
Yes,
little
please.
teeny break because this one is another one of my big ones coming up.
She's got flags all over this one.
Be a good time to take a little break.
This was definitely the one that the elected officials had the most feedback on as well. So why don't we take a 10-minute break and come back at 12:30? Does that work for everybody?
Perfect.
Okay, I am going to take my video off and we will resume. We'll take a quick 10-minute break. We'll come back at 12:30. It is 12:30 and I'll go ahead and come back into session and move on to consider approval of resolution number R 2020-37, a resolution adopting an employee alcohol, drug use, abuse, and testing policy. This is, as you might expect, this one we had, I think the elected officials, had a lot of feedback on this one. And there was some reference to drug and alcohol use and abuse and testing in the old employee handbook, which we're going to be updating here shortly, but not a whole lot. It was pretty silent on this. So obviously that's an issue for us. This gets back to, again, needing to have policies in place so that employees are clear on expectations, so that if we ever have an incident, which we hope we never have an incident with either drug or alcohol abuse, but that we have a clear pathway for how to handle it if it comes up. So with that, I will turn it over. And how about this? Sherry, do you have any questions? And if not you, we'll turn the floor over to Leslie. Did you have any questions to start with?
She's going to raise my questions, so I'm going to let her go for it.
I have a feeling that anything, it would probably be in this list. It's pretty inclusive.
It sounds comprehensive. So lay it on me, Leslie. What do you got?
Okay, so was this just CIS, or did any of our legal counsel look at this one?
So this would have been CIS's legal. So their pre-loss people would have signed off on this. Ours did not.
Okay. This was another one that I just struggled with, wondering if it was too restrictive, if we're delving too much into people's private time, into their own time, because I'm not as concerned about what somebody does on the weekend. And in some of the positions we have, like in the office and things like that don't involve driving a company rig like this as their job. But anyway, I might be thinking of the other one a little bit in this too. But let me look at my notes. Some of the things I was concerned about was that it talks about, like at the top of page 2, it talks about possession or use of a drug. I'm thinking about pain medication. that was one of the things that popped into my head about, like, well, what about someone that works in the office that has chronic back pain or something, if they have been prescribed some kind of pain medication? How does that?
Yeah, so if they have a prescription that would not trigger this policy, the only place where it would is there's a page. Let me find it really quick. There is on page 3, the second paragraph. What we do require employees is to let us know if they have a prescription that's going to affect their ability to perform their job safely. They need to let their supervisor know. And that is solely so the supervisor is able to provide an alternative that day. So like as an example, the example that came up is if somebody was prescribed something that they clearly shouldn't be operating a motor vehicle with. Occasionally you get those kinds of things. The expectation would be that they let their supervisor know that, hey, I've been prescribed this drug. They don't have to share what the drug is or the condition or any of those things, but that my doctor recommends that I not operate a motor vehicle. And so then it's up to the supervisor to then provide an accommodation for that day. And that's solely so that we don't have somebody who feels like, who disregards their doctor's orders because their job requires that they say drive, and then they do something that hurts them or another employee. But yeah, if somebody has a prescription drug, it would not trigger this at all. If it's prescribed, we're just talking about abuse of, say, drugs that were not prescribed by a doctor.
Okay. Okay. Thank you. Because and as I read this a little bit closer again last night, it was, you know, I just, you know, I didn't want people to have to just say, okay, this is everything I'm taking, you know, come to their supervisor and give them a big list of these are the medications that I'm on, as long as it doesn't.
Yeah, for HIPAA reasons, we do not want that to happen. We would rather not know those details, only the detail if it will cause a safety concern for the person or their coworkers. That's the only thing we really need to know.
Okay. Okay. One of the things that, and I don't know if I'm probably not going into order because I jumped around. I, of course, jumped around quite a bit. But another thing I guess I was concerned about is that is somebody, you know, we have 50 plus employees or whatever, and the people that are, you know, especially thinking about people working in the courthouse, if somebody, you know, chooses to use marijuana on the weekend, how can we, if we test them because we think they're acting oddly at work, and I don't know who's, you know, who was in charge of that determination, and they get tested or something, how would we know if that was, okay, that was 2 weeks ago or that was this morning? You know, how can you rule that out with something like marijuana that stays in someone's system for a while? I worry about people's own time and what they choose to do.
Yeah, this was definitely, I think of all the areas of concern in the policy, this was the one that we spent the most time as the elected officials group talking about. And the challenge here is exactly what you point out, is that, you know, obviously we don't want people using marijuana on county time, but because marijuana stays in the system, there's no way to know when it was consumed, basically. And so for now, sort of where we landed was that the policy probably needs to be most restrictive in that it doesn't allow it at all, basically. It should never be in your system if you're a county employee. And I know that caused a lot of heartburn amongst some of the elected officials, just for exactly your point. It's legal, they're adults, those kinds of things. One of the things that Sheriff Betancourt pointed out is that the technology just on testing just hasn't quite caught up, you know, and so the hope is that as testing sort of improves and as employers have this issue come up where it's legal and, you know, you want to make sure that people are not impaired while they're on the job, that the hope is that if testing improves where it can better tell us when that marijuana was consumed, that then we could look at this policy and have it reflect more of what our alcohol policy does, if that makes sense. So for now, we kind of took the most restrictive policy because there really is no way for us to determine if somebody ingested it on Friday night or if they went out during their break. And, you know, like we don't have a way really of doing that. So that's why the policy is as restrictive as it is at this point. The other thing that we've run into is just an issue of fairness in that our CDL holders and the sheriff's office, there is no tolerance for either of those departments to have any marijuana in their system. And so sort of out of fairness to everybody, if the sheriff's office or the road department could lose their jobs over ingesting, you know, over using marijuana, how do you allow the courthouse workers to do it on the weekends, but not everybody else? It was basically what it came down to. And how do we navigate that with the union where we have two different sets of rules for two different sets of employees on what they do on their personal time? And the CDL thing isn't really anything that we can control. That's a state law, you know, so, and the sheriff's office is no tolerance for obviously other reasons than the CDL. So that's what we did struggle with it as a group. And I think we ended up landing at, until the technology catches up to a point where we can pinpoint when that use happened, there's really no way for us to know if somebody is using on county time or not.
Yeah, oh, I can see, and I can see what you're saying. I do, it's like, gosh, I can see this from both sides really easily. I guess part of me thinks though that the people that hired on to do the driving jobs, to drive equipment and have to have a CDL, and the people that hired on to be in the sheriff's office, they knew that was part of it when they applied for those jobs. And so, you know, and that was a choice that they made. And people that apply for the other jobs, they maybe didn't realize that that was a choice that they were making at that time.
Mm-hmm.
But
Keep in mind that
in answer to your scenario of somebody's acting oddly and then we take them in and they test positive for marijuana. Well, if there's reasonable cause and they're acting oddly, then, and if they're not, if their tolerance is, and it's out of their system enough that they can perform their duties properly, then we're not going to know they did it over the weekend anyway.
True. I sometimes worry about people's, who determines what's the abuse of that on the part of a supervisor, say if they, you know, wanted to target someone, or, you know, that there's ways that you could use this against someone unfairly.
Mm-hmm. Yeah, and that we kind of get to it a little bit later when we talk about reasonable cause testing. But the idea, and we talked about this, is that that it needs to be authorized by an elected official to do the testing, and that needs to be in consultation with CIS pre-loss. So we would, before we would subject an employee to a test, we would have to run that by pre-loss just to make sure that we've, you know, that there is reasonable cause from an attorney's perspective, that they've met that barrier first. So that was sort of the expectation in the testing piece of that. And to Sherry's point, you know, we're not doing random drug testing throughout the entire county team. So it would most likely be triggered by somebody's behavior that would lead to a test, in which case we'd run that by legal counsel to make sure that we were, that we had sufficient cause to be able to do that.
Well, and you bring that up, that those other departments, if you have a CDL, you are in a random pool. And don't get me started on that, because I was in a position where the salaried employees were not in the random pool, but the hourly employees were, which to me was totally inequitable. And I lobbied for the salaried employees to be treated exactly the same way. So let's not get into that, or you're going to have me proposing that everybody's on randoms. Careful.
Okay.
Careful.
Okay. So good. That makes me feel better. I think part of my struggle with this one too is it's that philosophy degree, and you know that all the teachings of privacy and individual rights, and you know it just kind of comes out in me. One of the things that I had trouble with was searching people's property. People looking in somebody's purse or in their vehicle. I struggle with that. I don't know if that's a good idea.
I kind of agree with that one too. That's pretty invasive when you're doing the personal vehicle.
Yeah, and that definitely came up with the elected officials review as well. One of the things that gave them a little bit more comfort is making clear, it's on page 4, that first sentence, we added upon the employee's consent. So the employee has obviously opportunity to deny that consent. And then depending on the reason for denying it, the supervisor can then decide whether that employee is going to be disciplined or not. Depends on what it is. But so we try to sort of bridge the gap there so that the county does have the right, and county property is county property, so the county has the right to search county property at any time. But in terms of some of the other, like people's purses or cars, making sure that there's a consent process was important, and that was something that we added into the language after discussion with the elected officials. So I don't know if that gives you any more comfort with it, or if we want to explore that further.
The thing I noticed about the part about the consent was that it seemed like later, like in the next paragraph, it said, but if you don't allow consent, we can terminate you.
Yeah.
Potentially, I mean, it's hard to think of a situation where this will actually come up, to be honest. Most likely it would be a scenario where someone is claiming that somebody went out during the parking lot and was using drugs or something, or was, I don't know. In all of these cases, I would say that similar to the situation with testing, I think what we discussed as elected officials was this idea of like anytime we're taking one of these actions that potentially is very sensitive in terms of how the courts may treat it, that is a call that call needs to be made to CIS pre-lost first to run by their attorneys. Typically what they do when we make those calls, not necessarily about this particular issue, but about other employee issues, is they first ask what the policy is. They want to see the policy and that the employee has been given access to that policy. And then they'll ask you about past practices. I don't think we've ever had a situation where this has come up, so we wouldn't really have past practice. And then based on the circumstances, they would advise us on what's appropriate and what's not appropriate based on the law, basically. So I'm definitely open, if we think we need to look at different language there, we want council to take a second look at it, we could definitely do that. But I do think there needs to be some ability if we think that there's a situation that, like somebody's misusing or abusing drugs on county property, something like that, that we have the ability to search.
Sorry.
Go ahead.
I don't like the search. I'm not gonna, I just don't, I don't care for the search in somebody's purse, briefcase, or vehicle. I think that, can't we just do a drug test if there's enough indication that there's a problem while someone's at work? Isn't there other ways around it without having to search someone's property?
Potentially. We can explore that. I think, maybe the devil's advocate of that is somebody that's bringing it in and distributing it at work, may not be using it, maybe distributing it to other people. There's some other circumstances when maybe, but again, and part of this as well is eventually this crosses over into a criminal matter anyway, where Gary's folks would have rights to search with appropriate court authorization. So some of it may be taken care of, I guess, through that mechanism anyway, if it was that serious,
I'd like to hear what CIS's pre-loss people, just to give us a briefing on what that means and how common that is in a policy. Okay.
Yeah, we can definitely do that. Like I said, that came up as a concern with the larger electeds group. So what I will do is I will circle back with Tamara over at CIS about those provisions, the search of property and the employee refusal to test and search, and see what they recommend in terms of, what sort of standard best practices, and sort of how to bridge any concerns about personal privacy. Anything else?
Yeah, yes. I had a question about, where is it? Oh, this part, I didn't really care for this either. It says whenever possible, supervisors should locate a second employee or witness to corroborate reasonable cause findings. And I thought that seemed odd to me, to go to another employee and be like, hey, I think so-and-so's, especially when it's a suspicion, but it may not be true, to go to an employee underneath you and say, hey, I think so-and-so is doing something they're not supposed to. What do you think? And it seems strange to pull someone else in that's maybe a subordinate. I don't.
Yeah, I agree with that. That kind of threw a flag up for me too, as a second employee. Maybe that should be a second supervisor or elected, as opposed to, just a peer of the person that's being. I know at Waste Management, the requirement was someone in a supervisory position, that there were two people.
So I think I found it. So this is on page 4, right?
Yes.
Looking
Yes.
at, okay. So instead of employees, Sherry, you're suggesting we strike employee and maybe replace with supervisor?
Yes.
A supervisor, okay. Does that work for you, Leslie?
Yes, thank you.
Okay. Okay, we can definitely make that change. Anything else?
Okay, we're getting close. Yes, I said a lot of the concerns that I was very concerned about with, you've explained the rationale, and I feel a little bit better. On page 5, it says employees shall report to their supervisor any arrest for alcohol-related activity. And if the way that was worded, I thought not quite right. I guess I was just wondering why. In some situations, in some jobs, that it doesn't affect their day, they don't drive, or it's an arrest. It's not a conviction. It's just an arrest. So I just wasn't sure about that one.
Don't we need to be made aware in case it does become a conviction? Because if it happens outside of our county or our state, we're not going to.
Something else is any arrest alcohol related. So you're in a bar and somebody starts a fight and you all get arrested. I mean, it's a use related? I don't know. That was one I kind of struggled with too. Is it use related?
Oh, I'm losing everybody. Leslie and I are having issues with.
But you're more of an accessory.
Yeah.
I know, we're drawing lines of sand again.
It's okay.
Well, stop getting bar brawls and there won't be a problem, Nathan.
Yeah, I've tried, but Chet, you lead me down that road.
No.
Right.
Bring the assessor into it.
Yeah, the guy's not on the call. Blame him.
Blame him. I think we've got everybody back up now. Sorry about that. I don't know if it's a glitch in ours on our end or in the commissioners, but it keeps kicking us off. And so I think Teresa's.
I think it crashed because mine went down and it went back to Zoom when we started over again.
That's
Yeah.
what mine did too.
We'll blame Zoom for now. It couldn't be our internet. Our internet is great. in
I
Gilliam
had a little
County.
notice that said my internet connection was bad, so.
Maybe we had a countywide little outage there or something. So if we
could
do
get clarification on the search part, I would be okay, I guess, with the rest of it.
Okay, so I made the change on page 4, putting supervisor in where employee was on the locating a second. Did you guys want to add the word use under the criminal arrest or conviction?
Yes.
Okay, so it's clear that, you know, if you're in a bar fight and a bystander.
Sober. And you were sober.
And you were the DD, that is,
right.
It probably would be the issue. Okay, and then I will check with CIS's attorney.
It might fall under our bullying policy.
It may.
Right? I mean.
Which policy?
Anti-bullying or. We haven't got to that yet.
Anti-bullying. Okay.
But that's one we've been working on.
That one will come up in the employee handbook.
Okay.
And then I will check with the attorneys on the consent and search pieces. And so we'll plan on trying to bring this back, if not the 21st, depending on when I get some answers from CIS, then the first meeting in November.
Okay.
Does that work for everybody?
Yes.
Yes.
Any other changes or things that you want me to bring back other than those two and the consent stuff? Was that it, Leslie?
That's it.
Okay. Okay, I'm going to circle that so I don't forget. Bring it back, and let's move on to 7. Let's see, 7.10, which is consider approval of resolution number R 2020-38, a resolution adopting a surplus personal property disposal policy. Okay, so here's where this has come up. In our procurement policy, the one that we just adopted today, as well as the one I think that the previous court had, there was a provision that allowed for the disposition of surplus property. And that exemption allows it for up to $10,000. And when our attorneys were looking at this, they asked if we had a surplus policy in place, and recommended that we adopt one so that it's clear to county employees and elected officials what the process for surplus is. Where this has come up in particular is not necessarily the vehicles that we surplus. Where it's most probably pertinent is actually in Kelly's department, when we've got obsolete keyboards, mouses, computer monitors. Our attorneys suggested that we might want to consider setting a threshold of an amount of what needs to come before the county court and what can just be done through administrative signatures, so that we don't have to, every time Kelly needs to take a load of old computer equipment to the dump, get the county's court's permission.
Wait a minute. It's not the dump. There's a recycling for it.
To the recycling, to the electronic recycling center.
E-cycle. To e-cycle, that's the term.
To the e-cycle.
There you go.
So the draft that's before you was drafted by our legal counsel. This did not come from CIS. And it was reviewed by the elected officials. The big discussion around it, there were two things. One was ensuring that there was, since it's not going through or wouldn't be going through the county court, some of these, just making sure that there is adequate documentation about what happened for auditing purposes, so we can make sure that, you know, it didn't get approved and then an employee walked off with it, basically. And then the other thing was setting what the actual value the over and under, basically, value of what should come to the court and what shouldn't. And so there was a discussion about making it 3 or 5 or what to do, and I think we sort of settled on the lower number to ensure that things that were a little bit higher priced would go before the full court and be decided there. Questions about this one?
I have a, go ahead.
This is just personal property, does that not include the vehicles?
Personal property would be included under this one, but land transactions would not, because those have a separate state requirements. That those are much more detailed. So these would handle. Gosh, I think it kicked us off again. So these would handle like office equipment. I know my Zoom crashed again.
We can still hear you though.
Yeah, we can hear you.
I think it's our Zoom. Zoom saying, wait a second, you guys have been on here for 3 hours. This is a long meeting. Time to wrap it up, ladies. Zoom is saying.
Does this include vehicles or just personal property? Is there one?
So it would include vehicles.
Okay, so like there you go. The one we did today that's $800, that wouldn't necessarily have to come through us anymore then. They could just do
No.
that. Yeah,
It would just be done. The higher price stuff, like if the road department decided it was surplusing equipment, that would come before probably the full court, unless it was really on its last legs.
Right. Right. Yeah. Okay. Yeah. That makes sense.
I wasn't sure about the personal property. The fact that it was called personal property, that confused me just a little bit.
Well, the assessor has a personal property definition of what is personal
Yeah,
property.
that's basically any rolling stock or equipment used to do business that's not attached to the property, but doesn't have a license plate. So it's not,
Okay.
that'd be the state's, definition of personal property, but that's really for tax purposes. So.
Mm-hmm.
Yeah, the attorneys were really clear on this one that it needed to distinguish, it needed to call out personal property because that's what the exemption allows for. And the land transactions, which were the other kinds of surplus kinds of things, cannot be handled through this process. There's a detailed state process that has to happen for
It's all spelled out in ORS on how to just get rid of, properties we've obtained.
Yeah. So that was the language was definitely, because I had a broader use of language, and the attorneys were like, you shouldn't use that. So.
It talks about the contracting agency, and the contracting agency in this policy is designated as the county judge.
Yes. So the procurement policy itself, and this was the same under Judge Schaefer as well, the procurement policy itself designates the chief executive officer, administrative officer automatically as the contracting agency. So, that would be me in the administrator role that I have. So this is just clarifying exactly who that is, and it's also making sure, because under the exemption is actually up to 10,000. So what this does is actually put a restriction on me to be able to act unilaterally, because the policy says 10, the bigger policy, the procurement policy. This one would come in and say, actually, it's just 3 for this purpose, basically.
Okay. In what situation do you think that you would have to have a designee? And do we need that, or should it just say the county judge?
So the reason I put it in there, honestly, is with an eye toward my maternity leave. And I was thinking more along the lines of it being one of you, to be honest. so that if I'm out and one of you is designated as the person to take on administrative tasks, say while I'm on maternity leave, or in the future if a judge were to be injured or ill and not be able to come to work, then that would allow that to be designated to one of the county commissioners potentially. That was honestly what my thought process was to be able to hand it to one of you guys.
I wonder if it should specify that in there, a designee on the county court, or.
We could do that.
That was all the questions I had on this one.
Okay. So I can just add after designee on the county court under page 1 under procedure for disposition. Is that the only place you saw it, Leslie?
I think that was the only place I saw it.
Okay. So for this one, would you guys want me to bring back a clean copy with that change, or do you want to make a motion with the amendment?
I think we can make a motion with that amendment.
I think so.
Okay.
I move to adopt resolution number R 2020-38 as amended.
Second.
Okay, it's been moved and seconded that we adopt resolution number R 2020-38 as amended. The amendment being on page 1 under procedure for disposition of Gilliam County surplus property, adding the phrase on the county court after the word designee. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. All right, ladies. Awesome. We've got through the first round of policies. Before I go into the next stuff, I just wanted to preview kind of what's coming up from policy perspective. We've got an employee handbook revision that's coming up that we'll plan on taking up in early November because it's a 50-page document, so that'll give folks time to read it. We also are working on a cash handling policy coming out of the Treasurer's Office, just clarifying and putting in place all those expectations for how folks handle cash throughout the county. There's an employee safety policy that is being drafted now and going through. And then there's also a spending limits policy. So one of the things that when our attorneys looked at the procurement policies that we had, the one that we just passed and the one that the previous court had adopted, what they told us is that the court of old missed a step in that there should have been a policy that came with it that actually provided spending authority to people. Currently, there isn't. No one has authority except for me to spend any money at Gilliam County and us as a governing body. And so they suggested that we put one of those in place so that the elected officials and department heads and employees have some authority to spend, and that we're clear on what that authority is. And that sort of gets to your question, I think last time, Leslie, about Dewey's request about, what comes before the court and stuff like that. So that should hopefully clarify for all the staff when something needs to come before the court, when they have authority to.
I'm here. What does Zoom think I'm pretty sure Zoom thinks we're just taking us way too long today.
That's what I think. I think Zoom is like, okay, I'm done here. So let's move on to 7.11. This is discussion regarding the paperless courthouse initiative. I will just sort of give you the overview. So this is sort of a FYI, and with a final decision maybe to come a little bit later unless we're ready to do it today. Earlier this year, Teresa and Lisa participated in a webinar regarding the Oregon Record Management System. And what this is a paperless records management system that several of the departments have been interested in for quite some time. It's administered by Chavs Consulting, who also has our financial systems, you know, the accounting systems that we use, under a service agreement with the state of Oregon and the Office of Secretary of State Archives Division. So what the program does is it stores and purges public documents electronically according to state of Oregon retention requirements. And so we've been kicking this around and looking at this as a way to sort of modernize how we do business within Gilliam County. Couple of potential pros to it. The first one is because most of our documents are sort of historical documents, or a lot of them are just stored in paper format up in the clerk's office. If we ever had a fire or something went wrong with the sprinkler system or something, all of those documents right now are pretty vulnerable. We don't have necessarily electronic backups to executed contracts, to land land documents, any of those kinds of things that are stored in those county offices. There really isn't a backup. And so what this would allow, sort of the larger process, would be getting all of those documents scanned so that there's electronic versions. So if anything catastrophic ever happened and the courthouse burned down, we wouldn't lose all of Gilliam County's records, basically. There'd be an electronic backup for them. So that's sort of the first one. The second sort of positive is it would also enable us, I think, to allow more of our documents to be searchable by the public. So because all of ours are paper copies right now, you have to come into the clerk's office or you need to come into the assessor's office and have them pull those records for you. And so this would allow us, in some of the other counties, they sort of had an in-house for whatever reason, that would allow them to search online if they wanted to look for old land documents or things like that. And it would provide more public access to those documents. And then the third thing, from a resource perspective internally, is right now, I mean, Teresa spends quite a bit of her time trying to dig out old documents. What did that court agreement from 5 years ago look like? And was it executed? Did it have all the signatures on it? Sometimes on her computer, she has the electronic version, but we don't know if that's the final version because there's no signatures on it. And so what this would allow is all of the employees then, it allows you to sort of set different parameters for which employees can, like if you had confidential documents that only certain departments could go to, you can restrict access to those. But for some of the wider ones, like county business, contracts that we've entered into, it would allow staff to not have to go digging through old paper files to try to figure out what was actually done, and they could just search up basically to find those files and see the executed ones with copies. So I think that would help a lot. It also helps, if Nathan or Kelly need to see, say, a loan document that was executed, they don't have to come ask Teresa or go to Ellen's office to find the document. They would and find the information they need. So those are kind of sort of the three big upsides to it. The program is it was designed by the state of Oregon for governments. So it's really designed for exactly what we're looking for. The cost of the program is $370 and change per month, which gives us 10 user licenses, and then about, just shy of $40 per user per month. So anyway, I wanted to get to first of all, I wanted to put it on your radar that this is something that staff is really interested in pursuing. And if this sounds like it's worthwhile, then we would move forward with getting all the contracts in place with Chavs and the IGA with the state of Oregon. Because it's been contracted through the state of Oregon, it already meets all the procurement requirements up front because they did those themselves. So we don't have to go out and find two other alternatives or anything like that. So thoughts on this one?
Well, I am totally in favor of this. I have felt guilty when I've sent Teresa on some expedition to try to discover some information for me, and she's been amazing at pulling some things out, but I know that it's very labor intensive, and we need to come into the 21st century and act like we want to be there. So my question would be, the time and energy it's going to take to actually scan those documents into the system, and will each department be doing their own? Will we be hiring someone to do this project, or just?
Yeah, so
That was one of my questions too. Who is doing the scanning?
good
Could be labor
question.
intensive.
Yeah, so the way that it's set up right now, or the kind of team that's been working on it, is Teresa, Lisa, and Kelly. In terms of the very first thing that we're going to need to do if we decide to move forward with it is work with the state of Oregon and CHAVS to figure out the filing system. That's going to be really important. And sort of the protocols for how to name files, all those kinds of things. So they're going to have quite a bit of legwork in getting that sorted out and figuring out how to best organize, 50 plus years of documents that are going to need to be scanned. And then from there, it is probably going to be department by department. Some of the heavier lifts will definitely be like the clerk's office, obviously. The planning department has a ton of documents. For a lot of the court stuff, we can probably start by just everything new that we're doing, we're putting it in, and as Teresa gets time, or as we have summer interns, those kinds of things, we can tackle it. I would definitely expect that this is probably going to be a multi-year project. And for some of them, like for the clerk's office, we may be looking at needing to hire an outside consultant to come in, because some of those documents are just packaged in a way where it's harder to just throw them on a scanner kind of thing, where, contracts that are pretty easy to just scan, and we've got great, during the summer, high school interns that are in that can help kind of carry some of the bulk of that. So I would envision, and probably when we're looking at the budget, there may be some ask next budget season for some resources to be able to get this done. But most of the employees have sort of looking at, and so the expectation would be, when it's possible, that those departments start implementing scanning for new documents that they're creating, and then as they can get to sort of the archives, that they do that. So we don't have sort of a firm plan on here's what we're doing in every office yet, but definitely if we decided to go forward, I think the team that I mentioned would be coming up with, okay, this is how it's actually going to be implemented.
So
I didn't get all of that because I dropped off, but I get it.
The original documents will still be retained. And the question I had was like, are they do we have fireproof file cabinets?
So they're up, it depends on the office. Most of, say, our documents, the contracts and things like that, those are up in Ellen's office. I don't think they're fireproof. But a lot of Ellen's most critical documents are in the vault upstairs. So there is some fire protection there, and there is obviously sprinklers and things like that that are built in as fire suppression. Of course, they come with their own risk potentially in damaging documents, depending on.
Yeah.
Yeah. So there is some of that, but yes, the original documents will still be in place, but this just provides a backup copy, basically. The other nice thing about it too for our folks in terms of document retention is you can set document retention rules on each one as it comes in, and it will send a reminder to the department that these documents can be purged based on state law. So that's the other thing, is so that we, it's clear that, so we're not holding on to documents that state law allows us to purge, for like 10, 20 years kind of thing. So it kind of organizes that system as well. So staff knows they can pull it out of the permanent paper file as well as the electronic file.
Yeah, good.
Other questions?
No. Will there be a tutorial on how to use the system once it's
Definitely.
implemented?
In fact, I will not be updating or uploading any documents because I don't want to screw it up. So somebody will be teaching me how to pull documents, but I will not be touching the rest of it because I don't want to mess it up, basically. Well, great.
Hopefully,
so what else?
Hopefully some of the us users would have limited authority and access, you know.
What we can actually access, yeah.
I think there's a subscription that's a view only. So that might be my subscription. It's just a view only.
There you go.
Me too.
Well, they should
So
all be view only though. Once the documents are created and uploaded, there shouldn't be any way to edit them.
Yeah, and to be clear, the documents will be uploaded, but for like most of the offices, as they're creating new ones, they'll be able to upload new, the next round. So what this will involve is basically a contract with CHABS and an IGA with the state of Oregon. And so I will send both of those to County Council for her review, and we'll get those back on the court's agenda to approve those.
Sounds
and
good.
then that way, Kelly and Teresa and Lisa can dig into that this winter and come up with the protocols, and hopefully by next year we can start with the scanning and get that moving.
Yeah. I also wanted to say I appreciate all the work that's gone into those policies, and that's been a lot of work. So thank you to everyone that's been involved in that.
It's a team effort, lots of hours of reading and wordsmithing. So well done. So 7.12, which is consider approval of time value investments as additional institutional investment brokerage firm. And I see Nathan popped up. Nathan, do you want to clue us in, or do you want me to give an overview?
You can give an overview if you want.
Okay. So, so Nathan asked us to take this up. Basically, we're interested in kind of doing a comparison trial run with a second investment brokerage firm. So we are currently with, who are we with right now, Nathan?
Currently with, well, they just changed their name. They've changed hands quite a bit, but Fidelity is the parent group.
And so we're looking at the possibility of adding a second one, which is a time value investments, just kind of on a trial basis, I think, so Nathan can see both of them, compare pricing, compare service, all those kinds of things, and then ultimately decide which one we want to stick with, if that makes sense. So he's looking for authorization from us to go ahead and move forward with adding time value investments as a second brokerage option. Did I capture that?
Yeah, it was a lot more succinct than what I would have said.
Anything I missed that the commissioner should know?
Other than their fees are a little less, which is attractive, but ultimately it's about kind of balancing return with fees. I mean, low fees aren't any good if their service is no good. But the trend in our current, it used to be S&W Capital Management, but I've completely blanked. I can go look it up. The name of the new firm. But yeah, I don't think they don't give us any personal attention, which is, we don't have a ton of money there. It'd be nice if they sent us something once in a while besides the statements. So.
Do you guys have questions for Nathan?
No, we spoke already about it, so I'm good with it.
Yeah,
okay. Do we have a motion?
It's your turn, Weatherall.
I lost my paper.
Do you want me to make the motion? Okay, I'll move that pursuant to ORS 294.035, the Gilliam County Treasurer/Director of Finance is authorized to invest Gilliam County funds with Time Value Investments Incorporated.
Second.
Okay, it's been moved and seconded that pursuant to ORS 294.035, the Gilliam County Treasurer / Director of Finance is authorized to invest Gilliam County funds with Time Value Investments Incorporated. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, last one on the agenda is 7.13, which is consider approval of Oregon State Treasury, Oregon Local Government Intermediate Fund Investment. Nathan, do you want me to summarize? Do you want to take it?
Oh, you can summarize it.
I'll do all the work. That's
Yeah.
fine. So this is another potential opportunity for an investment venue area opportunity. The Oregon Local Government Intermediate Fund is managed by the State Treasurer's office. It's designed for municipalities. And the Treasurer is anticipating that returns over longer periods of time will be greater in this fund than in the shorter maturity Oregon Local Government Investment Pool, which sounds very similar, but is different apparently. Yeah, what else, Nathan?
This is really the first step in participating in this. So basically, if we're interested in participating or decide we need to, appoint them essentially as part of the motion. And the motion's real specific on this one. It comes straight out of the literature they send out. And then the next step is we have to submit our financial investment policy, which I am working on, to them for review, and they have to approve it. And then we can move into this. And really, it's managed by the same people that manage the LGIP. The main attraction is even lower fees than the other investments, but I think it's good to retain another investment firm because there's no guarantees. And I'm not saying the state of Oregon's going to go bankrupt or disappear, but who knows? Could be to get somebody, get a treasurer's office that's not doing their job at the state or something too. So the main thing I think keep in mind with this is there's more restrictions than just the local government investment pool. So local government investment pools, it's more like a money market account. You can put your money in, you can take it out relatively quickly within a couple days. And this time frame's a lot longer, but other than that, it's substantially identical. So.
Like how much longer, Nathan, just for comparison purposes?
They say a minimum of 5 business days, and then there's a limit on the number of transactions a month, which I don't remember. But,
okay.
Like the LGIP, potentially, if you get in there early enough in the morning, there's a cutoff every day. If you get in there early enough in the morning, you'll have your money tomorrow.
Oh, okay.
It's it can be, I think it's up to 3 days generally, the LGIP.
So it's not like it's going to be locked up for like months or something.
No, it's really, but it's, the fee structure is a little different, but it's really geared towards, intermediate investments, 3 to 5 years. And my hope is maybe the other bonds and stuff will be more like, longer term yet. So we'll have more like a step model, which we don't have currently.
Got it. Questions for Nathan?
We already talked, so I'm happy.
You got your questions answered.
I'm good. The meeting.
I'm good.
So do you guys have the motion language in front of you? You want me to make it?
I can do it. I found my paper.
Okay. It has to be exact, so.
I will stick to the script.
Okay.
I move to approve the use of Oregon State Treasury, Oregon Local Government Intermediate Fund, and as the governing body of Gilliam County, Oregon, the Gilliam County Court acknowledges the following. Members of this body and investment staff have read and understand the Oregon Local Government Intermediate Fund information pamphlet provided by the Oregon State Treasury. Investments in Oregon Local Government Intermediate Fund are subject to loss, and investments in Oregon Local Government Intermediate Fund and investments from Oregon Local Government Intermediate Fund may be subject to restriction by Oregon State Treasury.
Second.
It's been moved and seconded that we approve the use of Oregon State Treasury, Oregon Local Government Intermediate Fund, and as the governing body of Gilliam County, Oregon, the county court acknowledges the following. Members of this body and investment staff have read and understand the Oregon Local Government Intermediate Fund information pamphlet provided by Oregon State Treasury. Investments in Oregon Local Government Intermediate Fund are subject to loss, and investments in Oregon Local Government Intermediate Fund and divestments from Oregon Local Government Intermediate Fund may be subject to restriction by Oregon State Treasury. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. All right, Nathan,
Thank you.
go forward and invest.
Yeah, it's a good one.
Make us some money.
Self luck.
Good luck. Okay, we are at 1:30, and I think we're to announcements and next meeting. So next meeting will be October 21st, again over Zoom. Ladies, this is the day that we had tentatively scheduled to do a work session on our strategic plan. So a quick update on that. The community surveys came in at the end of September. And based on the feedback from the community and from the employees, I took a stab at drafting an initial strategic plan that is currently being shared with the elected officials and staff at Gilliam County. So the elected officials got it late last week, gave some feedback yesterday, and the employees got it last night and have about a week or so to get back to me with any of their thoughts and suggestions. And then it will go out in your packets, and we'll talk about it during a work session. So I wanted to see, I think we'll have a significantly lighter agenda on the 21st. So I wasn't sure if you guys wanted to start the work session at 9 or at 10, if you had a preference between the two.
If we started it at 9, would we be able to go right into the meeting, or would we have to then wait until 10?
We can notice, I was going to say, we can notice the meeting to begin immediately after the work session.
And I would be okay with 9.
Okay. Okay, we'll schedule the work session at 9, and then we'll do the meeting to immediately follow. Other than that, let me see what else I've got in terms of meetings. I don't have much. The Frontier 911 Board will be meeting on the 20th of October. Lots of AOC meetings coming up. And other than that, that's pretty much it this month in terms of public meetings for me. What about you guys? What's going on?
I only did a couple things. I participated in the Oregon Virtual Digital Government Summit over the last couple mornings, and that was interesting. You know, you always pick up some things, and talked a lot about how to, you know, working from home versus being in the office. And then I also attended both of the Oregon Department of Energy town halls regarding the chem waste notice of violation. And those were good and interesting as well.
How was the turnout, Leslie? I went to the virtual one, but I didn't make it to the one in Arlington. How was the turnout in Arlington?
The turnout in Arlington, I would say 20 to 30 people. There was not a lot. And I heard things later that people didn't know about it. So I'm not sure that attendance was down a little bit because people weren't aware that it was going on.
Got it. What
That's
about you,
all.
Sherry? What's new?
Well, I have, excuse me, I have Norcor Thursday the 15th. We have ethics training on Tuesday the 27th. And CAPCO on Friday the 30th. That's what's the big things on my calendar, and then other things to pick up.
Got it. All right, anything else for the good of the order?
I don't.
All right, then I will go ahead and adjourn the meeting. It's 1:37.